Well, welcome everyone. We have a pretty packed house this morning. We're panel one of the November 2025 case call, and as the court officer said, to my right, and first time to my right is Judge Randy J. Wallace, and my first time sitting with Judge Trebilcock. And he told me this morning it's his fifth time sitting as a during oral arguments, so he really knows what he's doing now. So beware of the questions. Be assured that all of us have read your briefs and other submissions, and we're well acquainted with the facts of your case. So there's no need to rehash or the law that's applicable unless there's something new. All right, now's the time to tell us something more than what was in your brief. This is a wonderful job that we have as Court of Appeals judges, and we spend all our time reading and writing. And some cases are sometimes more complicated than others cases, but that's all we do for a month at a time. And then we come out here for a couple of days. So oral arguments, the time for you to tell us something more than what's in your brief or explain something that may not have been as clear as you would have liked. By court rule, each party is allowed 30 minutes in total to argue if opposed, or 15 minutes if not opposed. Don't feel compelled that you need to spend 30 minutes up here. You don't need to do that. But keep in mind that the Court of Appeals makes a video. You're going to be on YouTube this afternoon. You'll be there for the next year or so, and then you'll be on the court website of every argument. So behave accordingly. And we caution counsel not to mention the name or location of any petitioner in an appeal involving a personal protection order or the name of any minor child in a termination of parental rights hearing. Case, excuse me. So without further ado, our first case for today is case number one on our docket, case number 369-555, People versus Marvell Christopher Elliott. And I see Mr. Simon here. Welcome, Mr. Simon.
Morning, Your Honor. May it please the court, Jonathan Simon on behalf of Mr. Elliott. I know that the people are not endorsed, and so I will keep my remarks brief.
Not only not endorsed, not showing up. So they're not here. Go ahead.
As far as new business is concerned, the court, I don't know, maybe or should be aware that, certainly that Mr. Elliott's first attorney died before trial, and he was received new counsel who has now become deceased during the course of this appeal. So he will not be available for a Ginther hearing as if the court decides that due to discovery issues or due to closing arguments by the prosecutor that a hearing may be necessary. We can still accomplish, I believe, through the testimony of Mr. Elliott and the prosecutor. However, unfortunately, Mr. Glenn will not be able to join us. I do find that this case is particularly disturbing for, I don't know, I was reading this and apparently the decedent, Mr. Anthony II, is the brother of the passenger, Mr. Anthony III.
Yeah, there's Ambry 2 and Ambry 3.
Yes.
The thing that kind of perplexed me about this case is he pushed his brother out of the car.
That was the point.
And I was thinking, and then he went to get his mother and bring him back, and they found him there with the police officer. It was just a shot spotter, I guess, was what alerted the police. But boy, I thought that was unusual.
That was very disturbing because he pushes his brother out of the car, doesn't call 911, doesn't ask for help. He just dumps him in the street and leaves. And to me, that's, I have brothers and I can't imagine ever doing anything like that. But it does, I think, show that there was more to this self-defense than perhaps met the jury's eye. And I believe that it is indicative that perhaps he was trying to hide something and that there was a reason for him leaving the scene in that fashion. And I think
he was questioned about that in cross-examination. defense counsel asked me, goes, why'd you leave? Did your brother have a gun? And he denied that. Correct? Ambry too?
Well, of course, but he also denied that his brother had shot up my client's house on a previous occasion. I don't expect him to be honest. He's the one who dumped his brother in the street to get out of there, probably to hide weapons, and which I think leans to the claim that there was no proof beyond a reasonable doubt that this case was not a self-defense situation. And for that reason, we believe that this court should find that the verdict should be changed and that there should be result an acquittal based on those grounds.
Counsel, why are those the issues that you raised with self-defense? Why are those not credibility determinations that are best left for the jury?
Well, they are, but I don't believe that the jury was able, a reasonable jury could find beyond a reasonable doubt that this was not an act of self-defense.
Wasn't there some evidence of that? Or didn't the prosecution put on enough to refute that theory?
We don't believe so. They have to prove beyond a reasonable doubt that it was not done in self-defense, and I don't believe that the evidence in this case bore out that burden. There's also, I think, the discovery issues, which I think handicapped counsel, and so that probably the trial process was not fair. And again, Mr. Anthony III was resulted in Mr. Elliott being convicted of an assault, which I think also defied logic because he may have been in the vehicle, but there was no evidence of any shooting in his direction. And so I think that there's insufficient evidence of that conviction as well.
Okay.
All right.
Any questions, Judge Wallace? No. Anything further? Thank you very much. Case is submitted. Have a good day. Okay. Well, you're done here. I was hoping it wasn't a case of wishful thinking on my behalf, but no, seriously, have a great day and good luck across the hall. All right. That case is submitted. Calling our next case number 2, it's a consolidated case of 3 different cases. Case number 371281, Tamara Pickthorn versus Oakland County Board of Road Commissioners. Case number 371457, Tamara Pickthorn versus Oakland County Board of Road Commissioners. And case number 371473, Tamara Pickthorn versus Oakland County Board of Road Commissioners. Council's present. We have Appley, you're entitled to 15 minutes of oral argument. Is that correct? Okay. Well, somebody go.
Morning, Your Honors. Trevor Potter on behalf of Defendant Appellant Oakland County Board, County Road Commissioners. This is the consolidated appeals of the trial court's denial of its motion for summary disposition. This matter has been extensively briefed, but there are a few items worth highlighting for the court. To impose liability here would make the Road Commission an insurer of all properties located near natural drainage paths or floodplains. Such a result is unworkable and would severely impact every road commission in the state. Assuming for the sake of argument that the culvert is even a part of the roadbed, the important question for the court is how is the road commission responsible for flooding a plaintiff's property which sits on a floodplain when there is no evidence beyond conjecture that defendant failed to repair or maintain the actual physical structure of the culvert. Plaintiff's responsive arguments merely amount to whataboutisms. The Green Road culvert and every other culvert that has been accused of need for repair in this case are functioning properly. Plaintiffs cannot escape the fact that they attribute the flooding on their property to the original design of the decades-old drainage system.
The original culvert, right? Wasn't there an original culvert there?
And then there was what I have referred to as the old Green Road culvert, which is on their property and was abandoned in 1971 and is now in possession.
It was before the subdivision was even there.
Correct. Before that, the home where plaintiffs reside was even built.
Right.
There's no road there, so there can't be a road bed.
Correct.
Let me ask you, how does a road commission or a municipality abandon a culvert or a road? Is there some formal process that needs to be gone through?
Yes, there was an actual recorded abandonment in the seventies that was recorded, public record, and submitted as an exhibit, part of the briefs, Your Honor.
Okay.
Importantly, the drainage district in this subdivision is under the jurisdiction, we have the Autumn Estates Drainage District, and then we have the Autumn Estates Drain. The drain is a Chapter 18 drain under the jurisdiction of the county, and the drainage district is a subdivision that drains into the county drain. These, the drainage district and the drain are under the jurisdiction of the Water Resource Commissioner's office, not the Road Commission. The Road Commission deals with the road and the culvert. The highway exception to governmental immunity provides that the Road Commission does not have a duty to design or redesign. It's not the Road Commission's responsibility to redesign this entire drainage system that's not under its jurisdiction in the first place.
Council, there's no dispute here. There's flooding on the property every year.
During seasonal abnormally high seasonal rains, based on the record evidence,
So in the spring or the fall, typically they get flooded. And we saw the pictures as part of the record.
and that was in July and I'd submitted data from the, I'm gonna get the acronym wrong, but from the National Oceanic, right? That showed that there was 3 times as much rain than normal, and that resulted in.
Is there any, my understanding of plaintiff's arguments, and correct me if I'm wrong, it's really the old culvert and it's not, in their mind, if the road commission would dig out the old culvert, most problems would go away. Is that fair?
It was fair with the plaintiff's initial inquiry prior to filing suit. When they reached out to West Bloomfield Township and the Water Resource Commissioner's office, and they were telling them, you know, you have this abandoned culvert in your backyard. We think this is the problem.
That's the problem, right? That was my understanding.
That's what we think the problem is, but I think once it was clear, based on the pre-suit investigation by West Bloomfield Township and the Water Resource Commissioner's office, that culvert was abandoned in the seventies and is on their property and they own it. But the argument shifted to the what I've called the New Green Road culvert and a few other culverts upstream and downstream.
Like one.
Correct.
Oh.
That now pointing the finger, I think frankly, in a pivot to find some sort of defect with these other culverts because the abandoned one is not under our jurisdiction.
And is there any evidence in the record? I didn't see any that whether it's the New Green Road or the Orchard Lake Road culverts are not maintained, in disrepair or anything of that sort.
There is no evidence of any blockage or need for repair with respect to the water flow. There's no evidence.
Well, the evidence would be the camera that they put through the drain, isn't it? But that's not dispositive as to whether or not there's blockage, correct?
So the camera actually helps the road commission. I would expect plaintiffs to disagree, but we did that inspection during the litigation because we're not trying to hide anything. So that was the Orchard Lake Road culvert, which has low flow.
That's the one that the Emily couldn't get through.
Correct.
Orchard Lake.
Correct, but it didn't get through because of an obstruction. It got through because there is an elevated level of water in that culvert, but it's functioning properly. And they put the Emily boat in, and the point of the Emily boat wasn't to get it through from one side to the other. It was because it had a camera, and can we see obstruction? And it didn't see any obstruction. And then, of course, we deposed anyone who did any sort of investigation prior to the filing of the lawsuit, which included an engineer from the Water Resource Commissioner's office, Jeff Wilson. And he went out and looked at Orchard. Well, I'll take that back because I don't know if he did, but he testified that we looked at Orchard Lake Road culvert and we didn't, there were no reported blockages. Your Honor, continuing with the lack of defects with respect to Green Road culvert, There's also been a theory developed in this case in passing without any scientific or expert support that the new Green Road culvert should be enlarged. Again, that would go to the design of the culvert, and that simply exceeds the duty imposed on a road commission by the highway exception under governmental immunity. With respect to the claims under the sewage system disposal event exception and inverse condemnation, although separate claims, defendants' arguments to those claims are similar in that the road commission doesn't have the authority to do what is being requested here with respect to the greater drainage system. The culvert, again, we don't have a duty to design to enlarge the culvert, and there's no evidence that that would even do anything. And it just goes back to the greater drainage district of the Autumn Estates Drainage District and the Autumn Estates Drain. That is the Water Resource Commissioner's responsibility and jurisdiction, not the Road Commission. So
Let me ask, representing both the road commission and the subdivision, or is the?
no, Your Honor, separate
Okay,
counsel.
and you
represents
split
the
your time up?
Yes, Your Honor.
Okay.
Yes, Your Honor.
How much time are you taking?
I'm frankly, Your Honor, I'm ready to end now, and I can pass it along to brother counsel.
Okay, you still have time, but it's good news that you're ending anyway.
Yeah.
But you still have time, but you've only used about 10 minutes. So, okay, I just wanted to give you the heads up.
I'm all set. Yeah.
Okay.
Thank you, Your Honor.
Thank you.
Okay. You have rebuttal time, by the way.
Good morning. May it please the court. David Kinzer on behalf of appellant North Potomac Green. So plaintiffs allege that the defendant subdivision property owners association own an easement running through their West Bloomfield property, which defendant does not acknowledge owning and has never acted to maintain. And plaintiffs allege that defendant's failure to maintain this easement has caused consistent flooding. First purchased the home back in 2011. So just on those facts alone, some alarm bells should be going off. Consistent flooding since 2011. Why is this claim being brought now? It's a claim for property damage, so it should be governed by a 3-year statute of limitations. Below, the trial court addressed this issue, the statute of limitations, and said, quote, "We have a continuing situation and worsening situation, so I don't see there being a statutory issue because it raised itself to a level of concern to put it within the statute." End quote. So cases like Terlecki v. Stewart, Maryland Frawling Revocable Living Trust established that the level of concern is not a relevant factor for determining whether a claim is timely, nor is whether the injury is continuing. All that matters is when the claim first accrued, which happens when plaintiffs first allege an injury resulting from defendant's most recent wrongful act. Here, plaintiffs, again, allege consistent flooding since they first purchased the home back in 2011. That's when the claim therefore accrued. It was therefore barred by time in May 2014, 7 years before plaintiffs filed their complaint. The statute of limitations would be a complete bar to recovery, so the court could stop its analysis there. If not, I'd like to focus my limited remaining time on the elements of plaintiff's trespass claim and what is missing there. I'd like to reserve 3 minutes for rebuttal.
3 minutes, yeah. We don't need you 3 times. Go.
I don't know, I'm pretty good. So Michigan has sometimes recognized claims from property owners concerning flooding on their property. But plaintiff's claim is not like any that's been recognized in Michigan before. Plaintiffs are not suing a neighbor who they allege are diverting water onto their property, or builders who they allege constructed the home with a defect, so rainwater was permeating the walls. They're not saying that the person who sold them the home misled them, giving them false assurances about the land's susceptibility to flooding. In fact, knew when they purchased the home that it was located in a flood hazard area, and they needed to purchase flood insurance before their bank would give them a mortgage. They toured the property too, of course. They could see that it was located at a low point in the subdivision. They could see this tributary, this easement running from west to east along the land's southern border, eventually draining into a large wetland, which is where all the water from this subdivision and the neighboring subdivision drain, just directly abutting the plaintiff's property. They saw all of this, or all of this was discoverable, whether or not they realized it at the time, and they purchased the home anyways. Quote, "We bit the bullet and said, oh, we'll figure this out later," end quote. Of course, figuring it out later was much easier said than done. Plaintiffs spent years emailing officials at all three levels of local government, city, county, state, and officials have tried to help them consistently throughout the time, but no one can stop rain from falling in a floodplain. So plaintiffs eventually filed this trespass complaint instead. Legally, the issues with it, in Michigan, to commit trespass, the actor must intend to intrude on the property of another. Another formulation from Adams versus Cleveland Cliffs, trespass requires proof of direct or immediate intrusion, meaning intrusion by any means the offender knew or reasonably should have known would result in the physical invasion of the property. In other words, if the intrusion was due to an accident caused by negligence, an action for trespass is not proper. Again, plaintiffs allege that the association's failure to maintain the easement has resulted in consistent flooding. Now, failure to maintain an easement is not intent to intrude. It's not an intentional act of any kind. Compare that to the alleged conduct that could constitute trespass. Building a dike to divert water from the new road on your land and divert that water onto your neighbor's land. That, the court said, could constitute trespass. Not this. It's not even clear, as co-appellant discussed, why plaintiffs maintain that the association failed to maintain the easement. What about the easement was broken or missing? Rather, plaintiffs see that the property is flooding. They speculate that this southern easement, as long as the other easement, may be the cause, and they assume that means the easements were poorly maintained. So now we're talking about evidence, C10 territory. Our brief discusses the natural servitude doctrine, that the property bearing a natural flow of surface water must continue to accept that natural flow, but a neighbor cannot materially increase the flow beyond that which is historically and naturally flowed. In this case, plaintiffs have never established a baseline what the natural flow of water was to start with. They've also not established the current flow. So it's impossible to say that the water levels have materially increased on the land. What we do know is that plaintiffs have been complaining about this consistently since 2011 when they purchased the first
Counsel,
purchase.
if I can ask you, why are we to disregard the evidence, or why should we disregard the evidence of homeowners association's efforts in 2011 to remove some issues? What doesn't that demonstrate control ownership?
Now we're moving from the elements of trespass to ownership, which of course appellant also disputes. And that is, so there are two specific acts. One is planting flowers north of the stream, north of plaintiff's property, in order to relieve some of the water flow. This is alleged from hearsay testimony. Nevertheless, it indicates a lack of intention to intrude on the property, an intent to relieve the water flow. The other action is when plaintiffs first moved in, that's back in 2011, and they wanted to clean the easements. They hired a company to do so. They requested that the subdivision reimburse them, and the subdivision voluntarily chose to do so, but made clear that they were not a party to the contract. It was plaintiffs who invited them on the land and who requested that they clean it, which to me indicates ownership by plaintiffs rather than appellant. So if plaintiffs could prove a material increase of the water flow, that still would leave the most difficult element of their proof to me, which is connecting this hypothetical increase to some action or omission by appellant. As co-defendant pointed out, Oakland County experienced 3 times normal rainfall in July 2021, right before plaintiffs filed their complaint. Plaintiffs need to show any hypothetical increase in water flow was more than those natural increases experienced by everyone else in Oakland County, and they cannot. Wrongful conduct, material increase, causation, they have evidence for none of it. No experts prepared to say that the easements were poorly maintained. No expert who will say that the home experienced flooding more than other homes in Oakland County. No expert who will say that any act or omission by defendant led to an increase in water flow. Don't mean to say that necessarily an expert is required, but that concrete evidence is required, something more than speculation, conjecture, and hearsay. Because plaintiffs have to rely on that, because they lack evidence of wrongful conduct, increased water flow, and causation, and because the trespass claim lacks an allegation of intentional conduct, we believe that the court erred when denying defendant's motion for summary disposition and request that that order shall be reversed. If there are no other questions, I'll reserve the remainder of my time for rebuttal.
Okay, thank you very much.
Thank you.
Let's hear from Appleby.
Your honors, may it please the court, Attorney Alex Ritter for the appellate. I think it makes sense to address some things that we just heard, and then I'll work backwards to Mr. Potter's arguments regarding the road commission. With respect to the statute of limitations, opposing counsel is completely whistling past the continuing harms doctrine and the continuing trespass doctrine, which makes it very clear under Michigan law that when you have a situation like this of continuing instances of flooding, the statute of limitations is not strictly applied to the first instance. It starts anew again after each flooding incident. And that's exactly what we have here. We don't have one singular flooding incident. We have multiple flooding incidences that started in the early 2000s, got worse progressively over time, reached a boiling point in 2021, and even after the case was filed, showed further instances of increasing in severity. We have figures from 2023 that we included in our motions for summary disposition that are referenced in our brief. And actually, that may have been the worst flooding incident so far. That was 2023. That was beyond that 100-year flood or 100-year rain event that
Counsel, just so
Yes.
I understand what you're saying is that the wrong that the claim is based on is the most recent. Most recent flood. What do you want to say?
Yeah, the initial claim was brought as a result of a flood that occurred in 2021 that was very much like prior floods, but more severe. This time it was, this has got to stop. This is becoming worse.
Harm alleged was the 2021 flood, and what they're seeking is damages related to that incident.
Well, the interesting part about the damages question is that that type of flood happened again and again and again, even after the case was filed. And, you know, there wasn't really a question of mitigation of damages brought up, but if there was, the trial court would have heard that we have in fact, you know, instituted some steps to try to alleviate the flooding into the basement. We've purchased sandbags and things like that, but I don't think that issue came up. The point is, it has
In terms
continued.
of timeliness, in terms of when the claim accrued.
There's not,
That's the date.
yeah, there's not even a question. We have an affidavit from Ms. Pickthorn expressly indicating and affirming that the flood event occurred in 2021, the same year that the complaint was filed. Just because flooding events occurred prior to that doesn't mean that this case is time barred. As a matter of fact, I think it establishes with this increase in severity, that this is the case that needs to be addressed now. So that's the statute of limitations question. The other issue that the HOA's attorney brought up was the elements of trespass. And again, I think there's this whistling past the graveyard with respect to the failure to recognize that we have the Wiggins case. The Wiggins case is extremely relevant and remarkably on point with the current situation. And I'm just going to quote, "It is beyond dispute that a defendant's unauthorized act of causing excess waters to flow onto another person's property constitutes a trespass." The HOA's counsel brought up the question of whether or not the excess water could constitute a trespass and brought up the question of intent. And I think there's a conflation here of intent to cause harm versus an intentional act. And the question of whether or not there's an intentional act, I think, can be resolved by looking at two different things. The first is evidence by an email from Jason Roselle. This is a February 3rd, 2020 email to the plaintiffs. Jason Roselle is the engineering inspector, planning and development services director for the, I believe he's for the township. And he said in that email that certain work within the HOA, or that the HOA had hired a contractor to try and improve drainage in some areas within the subdivision. And I'm quoting from this email. The work was started without permits, and the township informed the HOA/contractor that environmental/engineering permits were needed. This was not an engineered project, but more of a contractor connecting points A and B. So in other words, we have the HOA hiring a contractor to adjust the drainage in the subdivision, including connecting certain points of the stream to other points of the stream. That happened directly upstream. We know that from Mr. Winfrey's affidavit, where he said that this occurred in the common areas upstream. In other words, that was 2020. The very next year, we have this massive flooding incident.
But didn't Mr. Rossell, Roscl, also tell your client, in my opinion, the drainage easement is the least of your issues? I think the wetland behind your home is the biggest problem.
I think he opined at that time that he saw the wetland as being a problem. But one thing to keep in mind, and I was going to get to this with respect to the road commission's arguments, is that the wetland that you're referring to is connected to the Orchard Lake culvert and may in fact be experiencing higher or elevated water levels as a result of the issues with the Orchard Lake culvert, which we know beyond a shadow of a doubt exist because of their own inspection reports that identify low flow. And we have the testimony of Mr. White that says a low flow could indicate a blockage. So even if what Mr. Roselle had opined at that time is true, that actually establishes the claims against the road commission, or helps to establish the claims against the road commission. So that's going to, again, the affirmative acts, or the intentional acts element of the claims against the HOA. We have that Roselle email establishing that work was done by the HOA upstream just the year prior to that 2021 incident. We also then have the question of ownership or taking responsibility. And I apologize, but I forget which of your honors had brought up that prior work that the HOA had agreed to pay for. But I think that that's important because it goes to our main argument with respect to the question of ownership, which is equitable estoppel. You can't in 1 year take responsibility and agree to maintain an easement, and then in the very next year or in the later year decide, you know what, I'm not going to take responsibility because a lawsuit's been filed. And that's exactly the type of situation where the Michigan Supreme Court has recognized the case of equitable estoppel. And this is in the Markle versus William Beaumont Hospital. In that case, the Supreme Court explained that generally speaking, equitable estoppel, although not an independent cause of action, is instead a doctrine that may assist a party by precluding the opposing party from asserting or denying the existence of a particular fact. So in this case, we are asserting equitable estoppel to assist us in precluding the HOA from denying the fact that they are responsible for maintaining their easement or that easement, whether or not it's theirs or, legally.
Council, is it your position that whatever actions the association did or did not take in regards to the easement, is intent an element?
Intent is an element, but it's not
They have to not, so is it your position that they didn't, assuming that your position is correct, that they had a duty to maintain it, that they intended to flood your client's house by not maintaining it? They said, you know what, let's not do it. Let it flood.
Yeah, so the intent that the HOA seems to believe is necessary here is not actually the intent that's necessary. So they are assuming that the HOA had to intend to cause harm or intend to trespass, but that's not the case at all. The case law actually says that intent to cause harm is irrelevant. The only intent that is required is an intentional act. So it's not a scientific of, again, I want to trespass, I want to flood their basement. It's just, did you do an intentional act? And the answer is yes. And we know that through that 2020 Roselle email, that the HOA did an intentional act by doing the reconnecting of pipes upstream the very year before this massive flooding incident. And the trial court correctly found that that was enough to establish a question of fact as to whether or not they did something that caused the flooding.
Doesn't there have to be some intent that's directed towards the consequence? Like, is there no tying between that intent and the end result? The alleged harm?
Certainly, I think you could pose a question of tying the intentional act to the harm that was caused, and we can do that here because again, we have harm that's caused by a flooding of a drain. Tying that to the intentional act upstream, we have reconnecting the drains to help alleviate the drainage issues. Those two things are absolutely connected. In fact, they're one and the same. The drainage issues that are referenced in the Roselle email are the same drainage issues that are causing that are in fact the flooding on the plaintiff's property. Those two things are absolutely connected. There wouldn't be drainage issues for the HOA to try to alleviate upstream if not for the plaintiff's complaint about what's happening on their property downstream. I want to switch gears to the road commission's arguments. So, Judge Shelcock, I think you had brought up the question of whether or not there was any evidence of a lack of maintenance with respect to the Green Road culvert. And the Road Commission's counsel said, no, there's not any evidence. Well, that's not actually true. As a matter of fact, we have the inspection reports and the testimony of the Road Commission's own engineer, Todd White, who made it very clear that in the 45 plus years that this culvert has existed, not once did the Road Commission ever inspect or maintain that culvert. As a matter of fact, they didn't even know that culvert existed. And not just that culvert, any of the culverts within the subdivision they didn't maintain. There's not a single maintenance record of the Road Commission maintaining or inspecting any of the culverts in the subdivision at any point in time prior to this lawsuit being filed.
Well, why would they have an obligation to maintain a culvert that's not on a roadway or highway?
The culvert is absolutely on the roadway. And this is, I think,
You're talking about the new culvert.
Green Road
Oh, the
culvert.
new Green Road. I thought you were talking about the old one.
No, Your Honor. So we have actually, I think we can say 4 culverts at issue here. We have the old Green Road culvert under the Green Road that was abandoned in the 70s. We have the new Green Road culvert.
But can we agree that the road commission can't have any liability for the old Green Road culvert since it was abandoned like 50 years ago and it's not a highway?
So the position that we've taken in the case is somewhat an opposite to that. We believe that in the act of abandoning the culvert, the Road Commission has an affirmative duty to ensure, and this is actually in the statute, they have an affirmative duty to make sure that the abandonment itself is within the public's best interest. So our position has been like, look, Road Commission, you know how long these culverts last. Mr. White testified that they have a shelf life of around 50 years.
When would that statute of limitations accrue? The time they abandon the culvert?
No, again, the statute of
Or
limitations
it wouldn't
would
exist? There's no statute of limitations?
no, it would exist. The statute of limitations would begin to accrue when all the elements of the claim have been met, which means when the damage occurred in 2021. And the same thing with the continuing harms doctrine. I mean,
They could have abandoned it in 1920 and because it flooded in 2020.
that's right, Your Honor. because it's the continuing harms doctrine. You have repeated instances of flooding, but I don't necessarily want to just focus on the old Green Road culvert because our position has shifted as we've learned more. We've now found out that, again, they've never maintained the new Green Road culvert. They didn't even know it existed. They never maintained the Old Dominion culvert upstream.
Isn't that part of the problem though, is your claims in the lawsuit are controlled by the allegations in the complaint?
The allegations in the
So to the extent, you're not saying they've shifted from the amended complaint, are you?
Not at all. They've certainly been refined as we've gained evidence through discovery, but they have not even remotely changed. The allegations in the complaint still stand true to this day. And we did allege that there are issues upstream and downstream in the complaint. We just now know what those issues are. Specifically, or we have a better grasp of what they are. Specifically with the upstream culvert, and this is one of the 4 that are at issue. This is the Old Dominion culvert. Recently, I shouldn't say recently because this was over a year ago, but the road commission had posted that culvert for maintenance, and we're talking hundreds of thousands of dollars worth of maintenance. And the reason why, according to their own engineer, was because it either exhibited structural defects or was poorly constructed. That was the language he used. That's the culvert immediately upstream. Immediately downstream is
Language who used, Mr. White?
Mr. White.
Which culvert was he talking about when he said there's no blockage? Because we have flow through the culvert.
Ye-
Below flow through the culvert is because of the heavy vegetation on the east, on the downstream end. What
He-
culvert was he talking about there?
He was in that instance, he was referring to the Orchard Lake culvert. And what I had pointed out during his deposition, what I had argued in the trial court was, he never established that there was no blockage. And as a matter of fact, he admitted that he couldn't establish that there was no blockage in his deposition because the Emily camera that we talked about earlier couldn't actually see below the surface of the water. So if there was a blockage below the surface, it couldn't see.
How does his testimony getting to Judge Reardon's point where he says there's no blockage because we have flow through the culvert? Why isn't that, if there's flow through the culvert, there's no blockage?
He also in the same breath also said, well, if there's low flow, it could indicate a blockage. And that's exactly what we have is low flow. So I think Mr. White was trying to backtrack a little bit from the admission of, look, there's low flow that could equal blockage. And also, which was also compounded by the fact that, going back to this Emily camera, not only did it not see below the surface, it didn't even traverse all the way through the culvert. So even if there was a blockage above the surface at the far end, the Emily camera couldn't get through because the water level was so high due to, we believe, a blockage based on Mr. White's testimony, that there wasn't enough room for it to get through. So for them to sit back and rely on the Emily camera, that reliance is misplaced. The Emily camera didn't prove anything. So and I want to just be clear on what the arguments actually are, because we have 4 culverts, 2 of which are called the exact same thing. We have 2 Green Road culverts. Then we have the Orchard Lake culvert that we were just talking about with the low flow. That's downstream. Then we have the culvert upstream that is hundreds of thousands of dollars worth of maintenance that was ordered on it. That's the Old Dominion culvert. And so what I've theorized is a sandwich of culvert issues and flooding where my client's property sits right in the middle between an upstream culvert that has hundreds of thousands of dollars of defects necessitating maintenance and a downstream culvert that has low flow due to, we believe, a blockage. And we believe that the evidence that's been submitted to the trial court establishes that that blockage is in fact there. That's based on Mr. White's testimony. I don't know if your honors would entertain, if I have a minute or 2 left, reserving that for a SIR rebuttal.
No, we wouldn't.
All right,
because
very
the rules
good.
don't allow for it.
I think the only other thing that is important to bring up, and we haven't gotten into it, is this governmental immunity question. And I want to highlight the fact that this specific issue is a question, I believe, of first impression before the court, because it hinges on whether or not a culvert is a part of the roadbed. And what I've done in my brief is I've highlighted the fact that there's really no binding case law on this issue. So, you're permitted to, as persuasive authority, look to other jurisdictions. And I brought in that Ohio Supreme Court case that said, yes, a culvert is in fact part of the roadbed. And in their instance, they said under their highway exception.
So assuming that the culvert's part of it, what evidence is there beyond your theory, as you put it, that the new Green Road culvert or in combination with Old Dominion or Orchard Road is the proximate cause for the flooding?
It's the circumstantial evidence of 4 culverts, 2 of which we know for a fact have issues, 1 of which we believe was improperly abandoned, and the third, the new Green Road, is directly on our client's property, pushing out water at a rate that looks
So
equivalent to the Colorado River.
let's say we disagree with you and say it wasn't improperly abandoned. How do you get proximate cause with the new Green Road culvert that is operating as designed, and you've got testimony that there's flow and there's no evidence that it hasn't been, that it's in, it's not in disrepair, or it's not, at least not in reasonable repair.
One of the things that Mr. White said in his deposition, and we highlighted this over and over again, was if there's flooding, then that's indicative of a defective culvert. So the question is whether or not the culvert is causing the flooding. And that's where it's important to not just look at the new Green Road culvert, but to also look at what's happening downstream and upstream.
But isn't that a question of how all the culverts are working together, which is a design question versus the simple fact of a culvert's designed to channel water from underneath a roadway?
We don't believe so, Your Honor. And the reason why is because we define it more as a maintenance issue. Again, we have 45 years of zero maintenance to any of the culverts in the subdivision. We have the upstream culvert that since this case or this appeal has been filed, I believe they've actually finished the work, but it was hundreds of thousands of dollars due to structural defects or poor construction. So we know for a fact it was defective. And they never knew about it until this case was filed. They have an obligation statutorily to maintain their culverts. They didn't do that for 45 plus years.
So I guess if they've done all the repairs, is that then moot? Was it moot all the issues?
It may moot the question of whether or not they're going to be ordered to fix the problem, but it doesn't moot the question of the damages that have been caused as a result of their failure to maintain it in any of the 45 years prior to this case being filed. And that's extremely important here because we have hundreds of thousands of dollars in damages. We have the quotes from all of those, and I forget the names, like Metro Star Basement, there's several others, that went in, looked at the plaintiff's property and said, yeah, this is absolutely water damage. You can see that the pictures, the water's coming in through the windows. I think I equated one of the pictures to, it looks like the plaintiff's house is a houseboat, and it really does. Because it is just surrounded on all sides by water.
But just so we're crystal clear, if your clients are entitled to any damages in this case, they'd be limited to damages within 3 years of the date they filed the original complaint, correct?
That's correct, Your Honor.
I just warn you, according to my calculations, you have about a minute left.
Thank you. I think I'm done. I do have just one last point. If it is brought up on the question of whether or not the notice was adequate. And this is for the case against the road commission. This is under MCL 691.1404. We have laid out in our brief all the reasons why we've established each of those elements or necessary requirements of the notice statute, which is 120 days of the date of injury, the location of the defect, the nature of the defect, and the identity of all the witnesses. So, Your Honor doesn't have any questions on that. I think I am done.
Any questions? Thank you. You are done.
Thank you.
Thank you.
You have a few minutes.
Thank you, Your Honors. Briefly, just to touch upon a few of the arguments that were brought up with respect to the Old Dominion Road culvert. This road was posted for maintenance, so the road could be fixed. There is no evidence that there was anything wrong with the culvert or the water flowing through the culvert. Plaintiff has not set forth any evidence how repairing the road, which was posted for maintenance, so they said, all right, we have to decrease the amount of weight that we're allowing on this road, has anything to do with flooding on their property. It is pure conjecture. The low flow through the Orchard Lake Road culvert. I would think the many employees of the road commission that deal with culverts would understand that there's the idea of perfect flow for every culvert. You're not going to achieve it. There's too many culverts. And they're finding new culverts every day. That's their job. They go and find culverts to make sure they know where they're all mapped out and they're under their jurisdiction. The Orchard Lake Road culvert is working. It has flow. That's what it's designed to do. Regardless, is the proximate cause question. How is the Orchard Lake Road culvert, because it has low flow, impacting the upstream property of the Pickthorns? It's not. And you had the Jeff Wilson from the Water Resource Commissioner's office, not the Road Commission, who did his pre-suit investigation and looked at that culvert and said there's no blockage. And the plaintiffs asked him, you know, could this be an issue for us? And he said you would see major flooding over Orchard Lake Road first to be able to sew together any sort of causal connection between Orchard Lake Road and your house. And then we move to the wetlands that were mentioned, that plaintiffs' counsel referred to, stated that the wetlands are connected to Orchard Lake Road. Jeff Wilson, when he was working with the plaintiffs, went out to the wetland because that's Water Resource Commissioner's office jurisdiction. And they did some clearing. And when they were clearing, as he testified to, there was plenty of storage capacity in those wetlands for that drain to do what it does, to collect water. So again, there is no proof of causation that any of these other culverts are impacting the plaintiff's property. With respect to the difference between a culvert being in reasonable repair and evidence that you go out every year and maintain this culvert that you may or may not have known about, because the Road Commission is investigating, as I said, and finding new culverts all the time. That's the difference. We don't need to show that every year we go out and inspect the culvert. We just need to show that at the time and before, there were no issues with the culvert. And the representative for the Road Commission even went out to the culvert during the litigation and inspected it, and there were no issues with it. And again, with respect to the abandoned culvert, the Road Commission in 1971 didn't have a crystal ball that a home would be built adjacent to where it abandoned the culvert. Clearly, whatever the reasoning that went into moving the Green Road from its old location to its current location was intended for the public interest. And there's no evidence that the old Green Road was unsuccessfully abandoned. It was abandoned. With respect, lastly, plaintiffs have testified they've incurred $1,000 in damage to date. They've provided the affidavit of the diminution in value, and they provided quotes for things that can be done to paraphrase, waterproof the basement. They've only incurred $1,000 of damage. The Road Commission is not the insurer for homes to waterproof their basements when you build a home on a floodplain. The court has no questions. I'm off that. So.
Thank you very much.
Thank you.
Thank you, Your Honors. I would like to address the three main points in response to plaintiffs. First, it's the statute of limitations. Plaintiffs are relying on the continuing wrongs, continuing trespass doctrine. The Supreme Court rejected that in 2005 in Garg versus Macomb County. That decision has never been reversed. They're relying on a few out of context quotes from Frazier v. Haney from 2022, I believe. And they're not the only plaintiffs who have attempted to do this and revive the continuing wrongs doctrine. This court last year rejected that specifically. Haney does not stand for the proposition that the statute of limitations continues to run, however long the alleged harm is ongoing. A new cause of action can arise from the repetition of a wrongful act. As for ownership, they refer to the equitable estoppel doctrine that requires reasonable reliance. In this case, plaintiffs have not shown any reliance, that they took any actions based on either of the acts that they allege led to ownership. They had already purchased the home by the time that the Homeowners Association agreed voluntarily to reimburse them part of the cost for maintenance. because they took no actions afterward because they had already owned the home by that point. They also cannot show that they were prejudiced by this imagined reliance. They owned the home before the act, and it was susceptible to flooding before the act, and they owned the home after, still susceptible to flooding. And then as for intent, in the formation of intent that refers to direct or immediate. Let me get that. The defendants must have actual or constructive knowledge that their conduct would result in a physical invasion of the property. And the action that plaintiffs were referring to there, right, planting flowers upstream, they have not explained why that would reasonably lead one to believe that flooding would increase on their property. Again, the intention was to decrease the flow and relieve flooding for plaintiffs and for all the other neighbors in the subdivision. We therefore believe that they have not shown the requisite intent, and plaintiffs did agree that intent is required, and they haven't shown it. There are no further questions.
So you're saying that in contradiction to what plaintiff's counsel said, you're saying that the intent issue simply goes to an act that is performed by the defendant where the defendant either knew or should have known that it was going to cause the flooding and did it anyway.
Exactly. Yes, Your Honor.
Thanks.
Thank you very much. All those cases are submitted.
Thank
Three
you.
of them. Thank you very much. Have a great day. Calling number 3 on this morning's docket. I'll wait for council to move. Calling case number 3 on this morning's docket, case number 367856, NRA petition of Macomb County Treasurer for foreclosure.
If it please the court, Donald Visser on behalf of the claimant Butterworth here, also the appellant in this matter. I would request to reserve 5 minutes for rebuttal if I may. And taking the court's admonitions that you've read our briefs, despite the fact that I like what I said in my brief, I'll try to stay away from reiterating it.
You probably like to hear yourself talk too.
Not always. When I hear the recordings, it doesn't come across nearly as well as it did when it came out of my mouth. So I would ask, looking ahead, the court consider making this a published decision. This is an issue that now has come up at least 2 appeals where the FGU has solicited parties who are barred from filing to somehow intervene. The last one being the recently published Rivera decision on Mount Calm. There's a statement that's been made over the last 12 or so years that I've heard, probably going back further than that, but stay in your lane. The concept that stay in your business and out of mine. That concept fits for a different reason in this particular case, because it applies very much to the logical sequence of how the interests here are analyzed. And there's a lot of lane jumping here. We have 2 property interests, which I think are important to look at. The real property interest and the personal property interest of the surplus proceeds. That's been clarified out of the Sixth Circuit in Bowles versus Sabre. It's recently out of a published decision a few months ago out of the Michigan Court of Appeals in Kent County. What I call the Brott decision, it's consolidated for consolidated appeals. Very much recognizing that there's two different interests. And actually, Raffaelli addressed that issue when the court looked at the two takings that were involved, that the one of the fee of the real estate, which was not being challenged, but the taking of the personal property was. Personal property being the remaining proceeds. So throughout the descriptions, we hear that Banyan wants to get involved to protect its interest. Its interest in what? Is it a personal property interest or a real property interest? And it doesn't seem to be able to land on any one of those, but it clearly in this instance is a personal property interest. And so that makes a huge distinction as you look at the documents.
Which is a breach of contract claim.
That would be a breach of contract claim based upon the underlying note, which of course wasn't represented. It's not in the amended complaint that's filed. The only thing that's represented in there is the mortgage, which subsection 78K5E extinguishes. Subsection C extinguishes liens, but subsection 5 extinguishes all recorded and unrecorded interest in real estate. Now, if you really look at what is a mortgage, is it an interest in real estate? No, not really. We have some impediments as far as title and so forth, but it's by Michigan law, it's not an interest in real estate. It's a security interest. And what's alleged here supposedly is that in that mortgage document, the extinguished document, that somehow Butterworth assigned the interest. Well, then, is it assigned or not? No, really what the contract says, it's kind of an anticipatory. If you recover some money, then it's assigned. Well, that's outside of the recovery process. So if we stay in the two lanes of looking at whether it's real or personal property, the first thing we come across is the prohibitions or the limitations of 78L. Now, this is a post-Raffaelli case, so we don't have the same issues that we have because 78L was changed. But 78L now clearly prohibits this type of action. On page 11 of Banyan's appellee's brief, the last paragraph, it begins, Banyan holds an interest in collecting the tax foreclosure proceeds. What does 78L say? 78L says, if a judgment of foreclosure is entered, which it has been, under section 78K, and all existing recorded and unrecorded interest in a property are extinguished as provided by section 78K, then the important part, the owner of an extinguished recorded or unrecorded interest shall not bring an action, including an action for possession, recovery of the property, or any interest in the property, or any proceeds from the sale or transfer of the property under this act, except by following 78T.
Well, what about the fact that, was it your client that falsely represented on her form 5743 that there were no other interests in the property?
At the time that she submitted that, she believed that there were none because it's a non-recourse obligation. It's an elderly woman who had set this up as an IRA, and that's what she represented at that point.
But it was false, right?
I don't know that it was false because it's not an interest in the property. It's all it is security. That's where things get funny if you really want to get technical.
Didn't we allow you to go back or allow the appellee to go back and argue that? Or you go back and argue that in the circuit court? Argue whether or not that there was a false statement?
But you could go back. I think the recently published decision of Rivera covers that pretty well. It doesn't impact what's going on at the subsection 9 hearing that the court has, which doesn't include anything else other than just determining between two competing claims. Now, they might come in if there were two competing claims.
I mean, it's a separate lawsuit too, contract action.
Oh, I'm not, your honors, I'm never saying that there's not, that somehow everything is extinguished. If they want to sue on a separate contract, they may.
So
I will tell you, it's a dead end because it's a non-recourse debt.
help me understand. I understand your argument on 78L and the language there. It's clear, says shall not bring a claim.
Right.
Why is it not permissive or, by discretion, allow this to be litigated all at once? It's all the relevant parties. It's,
Because if you stay in the lanes, it's not the same property. They're claiming to have an interest in the real property. They're claiming to have a contract interest. They don't have an interest in the remaining proceeds. They didn't have one before 78T was passed. Clearly, they didn't have. If you look at the rationale, what happened with Raffaelli went back to the Magna Carta to determine that owners had a right to common law right to surplus proceeds because they were an owner. You can never replicate that for somebody who has a mortgage. You
Right,
just
I
Can't
understand
get
that-
there from here.
all right. I understand the distinction between the personal and the real property and why they're two different things, but why is it improper to allow, as Judge Wallace said, to litigate even if it's a separate breach of contract claim as part of this litigation?
Because it's not within the scope of jurisdiction set up under 78T. The legislature has severely limited what the court can do under 78L. And then under 78T says, this is what you can adjudicate. You must submit your notice of intention, then you must file timely. And then subsection 9 says this, you trial court make a determination between the competing claims. That's the only issue that's there. If you want to open the door and say, well, if I have a contract claim against anybody that's filed a cause of action, and I want to just tag it on to a remaining proceeds case, you're opening, I think, the floodgates for a whole bunch of sub litigation that has nothing to do and is not authorized by 78T. I just don't think the court has jurisdiction.
What if you just did a motion to consolidate the two, and the trial court would have two causes of action that it's proceeding through, judicial economy?
Right.
I don't know
Why
why,
couldn't they do that?
but I would argue there's no judicial economy because the issues are entirely different. But
Well, let me ask you this. If we were to agree with you and Banyan ends up getting dismissed from this case, and then they file their breach of contract claim against your client, are you going to argue res judicata?
no, I'm not going to argue res judicata. I'm going to follow the breach of contract and simply say you have a note which is non-recourse. I mean, that's pretty clear. That's pretty clear. This cat left the barn when did not file a motion. That's clearly what, in Ray Muskegon says, if you don't file a claim, you lose your claim. 78L says you can't assign. So this whole argument that, you somehow in the mortgage, you assigned it, whether it be real or personal property, 78L says the right to sue recognized by this section is not transferable except by testate or intestate succession. It's a harsh remedy. I'm not telling you it's not. I've been in front of other panels of this court complaining about how harsh 78T is and Ray Muskegon is. So this whole concept of forfeiture is an ugly concept as far as I am concerned. But it is what the law of Michigan is. It's forfeited if you don't end up getting in your motion or your notice of intention. I mean, by July 1, even before the surplus proceeds exist, you have to file a notice of intention. Then between February 1 and May 15, you have to file your notice. You miss it, May 16, you're done. Don't file it all, you're done. I think that's what Rivera very clearly, which was issued 2 weeks ago, very clearly says, is that if you don't make it, as recognized in their own brief, that's what they're trying to do. Banyan holds an interest in collecting the tax foreclosure proceeds. No, you're barred. It's flat out barred, whether we'd like it or not. I don't like the way that cookie crumbles. I have never liked the way In re Muskegon has come down. I don't think it's fair. I don't think, in fact, I don't think it's constitutional, but I've lost that battle. There are three judges on a panel that outvoted me, so that's where it sets. The only exception is what's come out in the In re recently, a few months ago, in the In re Kent County case that says that notice has to be investigated. But that's not an issue in this particular case. Everybody had notice. Banyan didn't file a claim. Now they're trying to get in the back door. They can go ahead. I have other cases where lawsuits have been filed by the other party to collect against so I'm admitting that that's a possibility. I don't think in this case it's going to be very successful, but I don't think we judge the process by what the results are going to be, because then we would have In re Muskegon to start with. So that's really where I'm coming from. And when you look at the analysis, there's no assignment of the surplus proceeds. So the way to get at surplus proceeds is only through 78T. 78L, if 78T doesn't make it clear, 78L makes it expressly clear. You cannot get there. Any action to recover any proceeds from the sale or transfer of property foreclosed for non-payment of real estate taxes under this act must be brought as provided under 78T. There's no contract actions provided for. There is nothing else. 78L wraps all causes of actions up into one cause of action under 78T. No exceptions, no excuses, no margins. It's solely where the court can go. There's no provision for breach of contract. And when you start looking at the application of the rules, that's where staying in a lane again start. Well, I had an interest in the property is what Banyan said. Well, you had a kind of an interest. It's not a real interest, but an ownership interest, but you had an interest in the the real property, which was extinguished. That was extinguished with the foreclosure. Now, do you have an interest in the personal property? I don't know where that comes from. This certainly doesn't come out of Raffaelli, and Raffaelli isn't going to get us there because there is no common law protected right following the same line that Raffaelli went. There is no common law right for a mortgage company. That's purely statutory. They come in maybe with a cause of action pursuant to 78T. But now then we have to work within the confines of 78T. So when you say I'm trying to protect, whether it be permissive or mandatory joinder, if you identify the property involved here as the personal property, there is no interest that Banyan can identify that they have or that it has against personal property. We don't even have to go to the extinguishment of 78K5E or C. It just doesn't exist because we're talking about a completely different property than what is in the mortgage document or contracted for in the. If they can show a contract that somehow there was some other duty, which I don't think. When we get all the documents together on that, including the non-recourse note in front of any court, that claim will go very far. I don't know if the court has any additional questions of me. I'll reserve the rest of my time otherwise for a rebuttal.
Okay, you have a few minutes for rebuttal.
Thank you, Your Honors.
Thank you.
Appley?
How do you do, Your Honors? Mark Miller, attorney for Appellee Banyan Investments. And thank you for the time to be able to speak to you. I have just.
No problem. We had to show up anyway.
Yeah, thank you. I have basically 6 points to go over with you that I think are important in this case. And there has been a lot of briefing, a lot of argument, and Thank you for going over it all. To me, this case is not complex. It's a simple case of a person who owes an obligation that doesn't want to pay it. Here you have an obligation owing of $55,000. And here the debtor failed to pay her taxes and she failed to pay her mortgage. Now, due to the good sale price obtained by McComb, she has the opportunity to painlessly pay back $39,000 of that obligation. This would be a simple case of a promise made and a promise kept. But contrary to conducting business honestly, Mrs. Butterworth has gone to great lengths to appeal to cheat Banyan out of the money he is owed. First, the first error of Butterworth.
The problem you have is that 78T is not on your side.
Correct.
I
Correct.
know
But-
equitably, maybe you're right, but at the end of the day, the statute's the statute. How can you get around it?
But in 78T, the statute goes and it explicitly says the lien of the mortgage is extinguished. It doesn't say the contract itself is extinguished. And you go
So you
through.
have a separate contract action. That's not before us.
Well, we have a separate contract action where she has assigned the proceeds. And so since she has assigned the proceeds, we are not claiming the money from the county. We are claiming the money from Butterworth, who is under the rule of the mortgage, is collecting those funds so that she can give them to us.
Butterworth, the defendant,
Butterworth is the appellee, the American states for the benefit of Butterworth. Yes.
So since the briefs in this case were filed, has there been a breach of contract action filed?
We have filed an action for intervention to take the assignment of the proceeds that have been paid in the Macomb County case. The one thing I want to note, it's been made a great deal of that there can be no delay. Nothing can get involved that will delay Mrs. Butterworth's or the owner's right to get the proceeds. That Mr. Visser goes should be very efficient. But one exceptionally distinguishing factor here is that Banyan, in intervening to request that, yes, you're collecting the proceeds, you have the right to the proceeds. We don't have a direct action to the proceeds against the county, but you are collecting those for us under the contract that still exists. We caused no delay because as soon as they filed the action for the funds, they requested the adjournment of that case and we filed our action during the adjournment.
Help me understand, as a follow-up to Judge Wallace's question, why not file your breach of contract claim, litigate that, you could even have an order or a judgment, and then just have that judgment filed with the county so the county, and, you know, basically have a lien on the proceeds.
Well, and that is,
Help me understand that.
okay. And in a sense, that's getting in part to the heart of the question. You know, they admit we have a contract action in their brief on page 4. But what they want the appellate court to argue is that we file a complaint, take up the court's time. We process it through to judgment, taking up the court's time. Then we process it through collection, taking up the court's time, where the intervention allowed by the judge within their discretion, pursuant to the discretionary intervention, allowed all of this to happen with one simple hearing. Yes, they have the rights to the proceeds, and we have the rights to them because they are collecting them on our behalf pursuant to their contract.
How long after this lawsuit was filed did you move to intervene?
Probably about 2 months.
2 months? And
That was all during
how
their
long was
adjournment.
that after you were supposed to file your claim under subsection T?
I believe that was in May, Your Honor. And yes, it would have been a lot easier if Mr. Banyan had realized the technicalities of the statutes and filed the notice of the claim and then put in the claim. That would have been simple, but he didn't realize all those technicalities
So,
and it came to us later.
but if we took your approach to its logical conclusion, wouldn't that read out of the statute, the mandatory requirement that our appellate courts have upheld is definite, firm and unmovable, that, you know, you can't have reasonable excuse. The deadline's the deadline. If you didn't file your claim, you're out, as harsh as it is.
And as harsh as it is, we are not filing a claim against the county. And I agree, we have no claim against the county for those proceeds. We have the claim because under the contract of the mortgage, the language is very clear that yes, Butterworth has the right to collect those proceeds from the county, but she is collecting them on our behalf pursuant to her written contract.
But so the tie is your written contract. What if I have a written contract where I did improvements to the home prior to the foreclosure?
Mhm.
And I'm a contractor and I want to get proceeds from that. Can I then, you know, also intervene and say, hey, I've got this breach of contract claim. I want to have
If-
proceeds.
If your contract had in it the language of the mortgage that had the language in it, like this mortgage, that if the homeowner collects any proceeds as a result of an action that extinguishes the mortgage or the mortgagee's lien, that you are collecting those proceeds for the mortgagee. So she signed a contract where she is collecting those on our behalf.
But if you're right about that, I mean, this appeal is 2 years old. By now, you could have had a non-periodic writ of garnishment served on the county and just be sitting around waiting to collect.
That
And yet,
that
here we
is,
are.
that is correct. And we took the simpler route of requesting an intervention based upon the assignment that she is collecting the money for us, and the court allowed it. Had the court not allowed it, then we would have filed the complaint and have been working on that basis. But the court allowed it in their reasonable judgment. And yes, I would, that is the main basis of our claim. And accordingly, you know, I request you to imagine a case where a person, Butterworth, voluntarily and in writing assigns all the proceeds, but then doesn't have to pay the proceeds. I argue Michigan law would require her to do so and enforce the intervention that the court allowed. And thank you very much.
All right, thank you very much.
Frank Friesha appearing on behalf of Appalachia Macomb County. Is there any time remaining or?
You have a few minutes.
Okay.
I'd say about 12.
Okay, well, that should be plenty.
All right.
We're the foreclosing governmental unit, and it seems to be there's some confusion here about claims against us for the surplus and the enforcement of the contract between these two parties. One of the things I heard is that you should have filed a separate contract. They didn't, Banyan did not file a complaint. They did file a complaint as a third party. There is a separate pleading alleged against Butterworth, which is basically a complaint. It was legally served. The appellant's counsel declined to accept service. It was personally served. So if this court feels it should be separated, that would be an option. It would need to be file a new complaint.
Help me understand, why does the county have a dog in this fight?
The county, well, one of the issues was multiple liability. And the other thing is the county wants to see that the right people get paid the right amount of
You
money.
still have the money, right?
We still have the money.
All right. So what difference does it make?
I could pay them. I think what happened here is Banyan, when I got the notice of intent and it said there was no mortgage, I looked at the title work. Title work showed a mortgage. It did not show a discharge. I wrote a letter to Banyan saying is the mortgage, sometimes mortgage companies don't file discharges. I wrote a letter to Banyan. Then this happened. Banyan says that was a false statement in the notice of intent. Banyan then was free to pursue this matter in which way they chose. They chose to file an intervention. At that point, I'm looking at it going, I would rather have this resolved. We heard Mr. Visser talk about, oh, well, the law is clear, Muskegon. I argued Howard in federal court. What he didn't tell you is there was a petition for cert pending in the Supreme Court on Howard and also on Muskegon. And I don't want to have to come back if this statute is thrown out, and likely, I think it won't be. But in the unlikely event, why not resolve everything at one hearing in the morning as the judge proposed?
So you're here arguing on behalf of judicial economy.
Yes.
All right, thank you.
So the other argument I heard is a 78L. 78L pretty much says that you have 2 years to sue the county. And it doesn't wipe out terms in the mortgages. I think it's clear when we foreclosed and obtained the judgment, it wipes out the mortgage as a cloud on the title of the property. It clears the title. It does not wipe out the covenants between the parties in the mortgage, and agreements in a mortgage are
I'm
called
not sure how
covenants.
much your argument's going to add to this.
Okay, that's fine. So the multiple liability, I didn't object. I think the right thing to do here would be to allow the court to proceed. And we give the surplus and the court decides who gets it between the two parties.
Thank you. Any questions? No. Okay, thank you very much. Rebuttal?
Your Honor. It just, brother counsel indicated, of the mortgage. Two different lanes again. Wants to go down the assignment lane. Wants to go down the duty to collect lane. One's a contract and one's an assignment of rights. Which one is it? And obviously, depending upon, are you looking at the real estate? Or are you looking at the personal property surplus proceeds? There's no assignment of the personal proceeds. And if there was an assignment of rights, then they had a duty to go ahead on their own to proceed, and they are barred by in Ray Muskegon. You didn't do it. You waived it. You forfeited it, according to In Ray Muskegon. Now, the duty collect, that's strictly a contract action. What other duties is the court being asked to open its doors to that can be alleged under the court rule for post-judgment motions? Anybody's got a claim against any debtor or creditor in a post-judgment motion? Can they go file to intervene because they want to protect their ability to collect from whoever the other person is in that particular case? I don't think it's a very good policy to do that, but I think the bigger thing is the statute just doesn't allow this court to expand the jurisdiction of what 78T, what the General Property Tax Act does through 78L and then through 78T.
So, just so I can just crystallize it for me in my mind, your position is that in this procedure under 78T, it's exclusive and you can't expand or add claims on beyond that.
I believe that's crystal clear under 78T and 78L. I think it's also, I don't see where post-judgment motions allows that additional. It's not like we started a brand new lawsuit and we're right at the beginning of a lawsuit and all the court rules apply. We do have this appeal in another case, exactly how much of the court rules apply to post-judgment motions. I've called the 78T kind of the unicorn of motions. It's, you've got foreclosure actions that have been closed for years, final orders. And all of a sudden the legislature said, well, you get a motion at the tail end here. We really didn't adjudicate all the rights. We've given you a new one at the end here. So where does that fit in with the court rules? There's no complaint. There's no answer, that type of thing, unless you go back and say, well, the complaint is really the petition for foreclosure. So what part of the court rules, I think that's all buried in here is, do you want to expand the court rules beyond what the legislature said you have to do here in 78T? And then when you look at what's permitted under post-judgment relief, that portion of subchapter, I think it's subchapter 6. It doesn't,
So really on the surplus, it's an administrative proceeding. It's an administrative record. The record is closed and it's who's entitled to proceeds.
that is what I have been argued. I think that the Court of Appeals in Rivera case agreed with me on that, saying the treasurers or I should say the FGUs, the foreclosing government entities, don't have a role in this other than providing the court the various administration. That's why I've taken issue with Brother Garcia's effort in this point to expand it. If there's no faith in the prohibit or the provisions of 78L, then and 78T, then I think it's incumbent for Macomb County then to challenge that and bring it up as opposed to simply backdoor the process and simply say, well, I want double assurances. You know, I just don't see where there's any suggestion under 78T9, which is the court's role for any of this. And then if you look at the gateway to get to 78T, you'd have to go through 78L. And that just cuts off so many avenues here. It says you cannot do exactly what they said Banyan said is doing, is seeking to collect the proceeds. Well, 78L says there's one way and one way only that you do that in compliance with 78T. You made to sign. So if they're going to claim assignment, whatever, is that personal or real property, they're going to claim assignment. That's against public policy. I'll point the court to Peterson versus Kent County for looking at if the legislature sets forth something in a statute and the counties or a governmental entity does something different, that's against public policy because the public policy is announced by the statute.
Well, I think we got your argument. You're running out of rebuttal time. Do you have anything else?
I have a whole lot to say, but I'm going to sit down.
I have one question, just to extrapolate on something that you said. So your client didn't have an obligation nor even really ability to file an answer to the intervening complaint because it wasn't a defendant in the case, correct?
That's correct. Not until the court allowed intervention and the filing of a third-party complaint. It's not a cross.
Well, even the third-party complaint doesn't list your client as a, the intervening complaint does not list your client as a party.
It's
Or, I mean,
basically
as a defendant.
because it's looking again to grab onto these remaining proceeds. And something that's just barred. That's why I've been in trouble all this time with jumping around between the two lanes. And I don't mean to be disrespectful because usually when someone says stay in your lane, it's usually quit getting in my business. But I think the analogy is appropriate that when you really look at it, staying in a lane, looking at a real property versus personal property, you can't get there from here.
Thank you. Thank you very much. We're going to take a short, have a great day, by the way. Well, yeah. We're going to take a short break, even though we're not on to our 11 o'clock case call. We're going to use the facilities for a few minutes, but we'll be back. Trust us. Okay, thank you for indulging us in a well-needed break. So we're back in action. Calling the fourth case on our docket this morning. Case number 371115, Deborah McClellan versus Constanza Hooker.
Morning, judges. Robert Siegel here on behalf of appellant Deborah McClellan, who's actually with us today. I know you've read the brief, but just in case something may have slipped through. This is the case concerning Ms. McClellan's paid therapist and spiritual advisor, who upon hearing that she'd come into an inheritance and got some money from a stock sale and wanted to buy a house in Detroit to conduct a ministry, took advantage of her vulnerability by tricking her into getting some property titled into an entity that she had her set up, and then Ms. Hooker, who is the, one of the appellees, control. And she accomplished this manipulation through representations and promises that Ms. McClellan would possess the property, control the property, et cetera. And she wound up directing her to have the property conveyed directly from the seller to this entity, the other appellee, Uncork Build, who again was Hooker controlled. And yet 3 days later, changed the locks, prevented Ms. McClellan from having anything to do with the property. And
And never let Miss McClellan live there. Didn't she think she was going to live there?
No, she was going to conduct her ministry
Okay.
at the house. And, but she was locked out and it was listed on Airbnb.
Okay.
So totally different deal. So this lawsuit ensued. We have 5 counts, one of which is the quiet title and the other, fraud, innocent misrepresentation, breach of fiduciary duty with undue influence, promissory estoppel, which was candidly mislabeled as equitable estoppel. So the defendants proceeded to file a motion for summary disposition under 2.116 C8 and C10. And what this appeal is really about is procedure gone awry, because the motion itself was only directed towards the quiet title claim based upon claims that the property was a gift to Uncork Build, and that because Ms. McClellan doesn't appear in the chain of title, she has no claims. The appellees filed absolutely no affidavit to support their motion, no evidence whatsoever other than irrelevant documents such as layer documents showing the incorporation of Uncork Build, its articles of incorporation, a copy of the deed, which is just not relevant on the face of the statute, and some discovery responses which actually contradicted their view. And again, despite the fact that the motion was purely and literally and on the face of the record at the hearing was for quieting title, the trial court proceeded to dismiss the entire case. In the absence of any evidence, in the absence of any discussion, entirely based upon attorney conclusions. And the only basis for its decision, as I'm sure you remember from our briefs, is that Ms. McClellan does not appear in the chain of title, and therefore she loses.
Who was that? Judge Gillis, who was very short shrift, his opinion. It was on the record, wasn't it?
Oh, yeah, it was on the record, and it was like one sentence, and it was basically, I actually want to read to you, I think it was the court, Judge Gillis actually acknowledged the existence of a genuine issue of material fact by stating, and this was just before he ruled, and I quote, "Perhaps she gave a gift to Uncork Building Corporation. I don't know." That, by the way, is at appendix page 117, lines 14 and 15. The court's decision was an absolute disregard for every requirement of the court rule, and I'm talking specifically 2.116 G3, 4, and 5. G3, they didn't offer any evidence whatsoever to support their motion. Again, part of it's C8, but if you look at the transcript and you look at the pleadings, they really didn't argue anything that would be applicable to C8 other than somehow a belief that because the property never actually was titled in Ms. McClellan's name, that somehow she loses on her quiet title action. They also failed, at least as to counts 1 through 4, the counts that were not to quiet title, didn't even in the motion specify those as issues that they contended lacked a genuine issue of material fact on. And that in and of itself, Ms. McClellan would have been justified to not even respond to those.
What allegations in the complaint go to misrepresentation of facts or fraudulent misrepresentation of facts that occurred prior to the transfer? I understand the allegations that there was this transfer. It seemed like the parties were in agreement up to the closing, and then where the bad stuff happened, to put it pretty simply, occurred after closing.
Yeah, no, I think you're probably talking about the concept of fraud typically relates to current or existing facts as opposed to promises in the future, which might be more properly directed towards a promissory estoppel claim. But there's exceptions in this point. I mean, keep in mind, the representations are, you're going to buy this property. I mean, they had her pay $5,000 to set up this uncorked build company, which only Ms. Hooker controlled. And what's going to happen is you're going to buy this property, you're going to pay for it, which she did. The evidence shows that. You're going to have the seller convey it directly to uncorked build. And what we're going to do is you're going to conduct your ministry at this property. You're going to possess the property. You're going to control the property.
So the fraudulent misrepresentation is not, it's not the $5,000. It's not the sale or the purchase of the property. It's not that it's going to be put into this LLC. It's that ultimately she didn't control and possess the property.
Yeah, she was supposed to control everything. And there was exceptions as I enumerated, in our brief, to the requirement that it has to do, representations to be actionable fraud need to be as to existing fact. I mean, these promises were clearly a device to perpetrate a fraud. That's an exception. If we'd ever been able to get that far, which we weren't able to conduct anything, if there was a present intent by Ms. Hooker not to perform, that's an exception. And also you take into consideration that this was a relationship of trust and confidence. This was her paid therapist and spiritual advisor who knew she came into some money and wanted to do this thing and use that to manipulate her. These are clear exceptions to this rule that I think you're inquiring about. I hope that answered your question.
Well, I guess my question is I'm just trying to understand the distinction and really pinpoint whether it's the misrepresentation or the undue influence. It seems to me that they were on the same page in agreement. There was no undue influence in terms of purchasing the property. Like just if you look at, they agreed, we're going to purchase the property and it's going to be this piece of property. We're going to purchase it. You're going to pay for it. It's going to be titled in the name of this company. No misrepresentations regarding that.
Well, I disagree.
Okay. And it helped me understand that because what I understood it to be is they're all on the same page for that, but it's what happened after the sale and they say, pulled the rug out from under her and said, well, actually, it's not going to be a place of worship or whatever. We're going to do it as an Airbnb.
All right, because I don't think you really can look at it as isolated as I think your question assumes it to be, because the deceit and the fraud itself was obviously not disclosed until, well, we changed the locks. You're not going to possess it. You're not going to control it. And guess what? It's going to be listed on Airbnb. And so if you look at the representations, I think you have to look at it, kind of more globally. Yes, if you were to say, yes, we're going to have the property titled in Uncork's name, looking at that on an extraordinarily isolated basis, was that true? Well, yeah, it was. Why was it supposed to be listed that way? Why? And you got to look at the promises of this is what we're doing this for, this transaction. And when we look at undue influence and the presumption of undue influence, we look at the nature of the relationship. We look at the whether or not the person making the promises, in this case, Ms. Hooker, either personally or an entity or something she had an interest that benefited from the transaction, which Uncorked Bill did, and whether she had the opportunity to. So if you look at that.
So where would we then draw the line in terms of lots of times there may be, you represent, we're going to do this, this, and this. You do everything, but circumstances change and you pivot. And it might not have been what you talked about 3 months ago, but you've done, everything through the close, through the purchase, but then you pivot. Where do you draw the line?
Yeah, I mean, this isn't like a contract between equally informed businessmen who are saying, look, we want to start a business. And okay, circumstances change. Guess what? Our Burger King concept isn't going to fly. We got to make it more of a sit-down place. That's not the case we're dealing here. You're looking at it, this transaction was basically maybe one long run-on sentence, but you're going to buy the property, title in Uncorked Building's name, so you could run your ministry that you are going to possess, you are going to own. To me, that is one, for all practical purposes, given these circumstances, one promise.
So the promise is a house of worship.
Yeah, that was the deal. This wasn't like we're going to go into business together. And like I said, my Burger King reference, was, okay, things have changed now. I mean, this is what you do. She was her therapist. She knew she wanted to run a ministry. She knew she came into some money and wanted to buy a house to run her ministry. So what happens? This is, we're going to set it up. You're going to pay for some nonprofit corporation. You're going to have the property directly conveyed to it. You're going to possess it. You're going to control it. It's going to be your ministry. But what happens? Literally 3 days later, you're locked out and it's on Airbnb. I can't imagine. I mean, to me, that's just outright fraud. And again, I understand what you're saying about the representations didn't relate to past or existing fact, but I believe all of the exceptions to that rule exist in this case. And even if they didn't, then we have the promissory estoppel aspect of the case.
Well, you're really just arguing fraud in the inducement.
I mean, basically, if you want to look at it that way.
I'm looking at your complaint right now and it has all the elements of fraud in the inducement.
Yeah.
It doesn't call it that, but it sounds.
Well,
like fraud in the
I grant
inducement.
Mr. Jensen's complaint was not the most artfully drafted complaint. But
Well, we
it is
look
what
at,
it is.
we look at how the complaint sounds, though. We don't look
Yes.
at how the parties label each count.
Right.
Going back to the quiet title.
Okay.
Your client didn't have her name on that title, didn't have any lien on that title or anything. Right?
That's correct.
Isn't that a necessity to bring an action for?
Absolutely not. If you look at the statute, MCL 600.2932, it on its face doesn't require that. First of all, and I'm reading from subsection 1, any person, whether he is in possession of the land in question or not, who claims any right in, title to, equitable title to, interest in, or right to possession of any land may bring an action in the circuit court against any other person who claims or might claim any interest inconsistent. And so on the face of the statute, there's no requirement of title. I mean, it's a determination as to who has the superior right to this property as between parties who are before the court. And in this case, Ms. McClellan did claim rights in an equitable title to and a right to possess the land, as I believe is articulated in the complaint. And also to some extent, premised upon the fraud is the only reason why this was ever put in on Court Bill's name. And I think the Stewart v. Panic case that I cited the quiet title is an equitable claim. There's nothing in the statute that requires someone to actually have title.
But didn't Beulah Hoban, Appleton Qualified Personal Residence Trust hold a little bit differently?
I'm so sorry. Can you repeat that?
Beulah, Oakland, Appleton Qualified Personal Residence Trust hold differently. I thought that case said in action under quiet title, the plaintiffs have the burden of proof and must make out a prima facie case of title. They must have a title.
I don't have this. I apologize. I don't have this particular case in front of me. I looked at every case. I read through every single case they cited. I did not find a single case that actually stated you need to have title. The requirement to show title as set forth in MCR 3.411 is if you can rely on it at trial, then you have to attach it to your complaint. Ms. McClellan was not relying on title. She has no claims against the seller, Mr. Hosini or whatever his name was, that actually conveyed it directly to on-court bill.
Would you agree that you have to overcome all the other hurdles and be successful on at least one of your other claims before you get to the quiet title? Because doesn't she
Yes.
first, yeah.
Yes, I do agree. I do agree that the claim to have a right or equitable title or other interest in this property is absolutely premised upon the fraud, the undue influence, breach of fiduciary duty, et cetera. Yes. But the title isn't a requirement, and that's all the trial court considered. There was nothing before the trial court as to whether or not Ms. McClellan had pled a prima facie case of fraud or promissory estoppel or a fraud or of breach of fiduciary duty and undue influence. That wasn't part of the motion. That wasn't part of the discussion. That was not in any way part of Judge Gillis's decision. He basically said, oops, you're not entitled. The whole case goes away. Well, I frankly, as I think you understand from my argument here today, fervently believe that our position regarding the quiet title claim, and you don't need to have title. But even if that were to go away, there was absolutely no basis whatsoever to dismiss counts 1 through 4. They weren't a part of the motion. They weren't supported by them. The court rules absolutely required it. They didn't come forth with any evidence to support it. That's required by 2.116 G3. They did not specify any of those as issues as to which they contended was not a material, genuine issue of material fact. That's G4. And based upon the record, Judge Gillis did not even consider the evidence that Ms. McClellan had come forth with, which is a verified complaint, an affidavit, and documentation showing she paid for the house, as well as her discovery response, which directly controverted what they were saying, that it was a gift. So basically, Judge Gillis said, okay, she's not in the title without considering anything else. Boom, the whole case is gone. To me, that makes no sense whatsoever. Every part of this court rule was ignored by the defendants and by Judge Gillis.
If we agree with you, hypothetically on promissory estoppel, or I think the complaint called it equitable estoppel, do we really need to consider anything else?
I haven't analyzed it to the point of there were any different forms of relief that one might be able to garner based upon, let's say, a ruling in favor of promissory estoppel as opposed to fraud. But I mean, frauding, or I'm sorry, I misspoke, or the breach of fiduciary duty. I think other than the element of potential difference of damages, which frankly we didn't brief because it wasn't an issue. No, I think not. I think if it's promissory estoppel, then is there really a practical difference between that and fraud other than the elements? Like I say, with the exception of the potential relief she'd be entitled to, no. Although I believe under these facts, it'd be considered either fraud because I think those exceptions to promises in the future apply. So it could be both. Practically speaking, again, with the exception of potential relief, I don't know that it would matter whether you go in favor of her in terms of the promissory estoppel claim or the fraud claim. I mean, I guess lastly, I think it's interesting that they did not really address any of our issues head on in this case, and they don't really seem to contradict any of the facts, presumably because by doing so it would be a tacit admission that genuine issues of fact exist all over the place. Unless you have further questions, I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you very much. Thank you. You have rebuttal.
Good morning, Your Honors. Julie Crota on behalf of the appellees. This is an unusual case, and I have to start by saying most of the facts that you were just provided with, probably 95% of them are not even part of the record. What happened in this case is we were served with a complaint, and the structure of this complaint is that the appellant in this matter had actual knowledge that she was not going to be an owner or grantee of the property, the subject property that's at issue here. She doesn't dispute this. She's the one who set this up. Almost 2 years later, she was unhappy with it. She tried to unwind her gift by using different theories. And of those theories, the complaint first stated that this was for foreclosure of an equitable mortgage. That issue was then dropped. It wasn't really even pled. It was certainly not ever brought up again. So there was the allegations of fraud.
So your case rises and falls and solely that this was a gift. Is that right? That's your position? This was a gift, and so all these other claims go away. What's your best evidence that it was a gift?
Well, the only evidence that came in was the deed.
Okay,
So
so because
that's our-
she's not listed on the deed, that's evidence that it was a gift.
Well, it's our strongest evidence that the deed came from a gentleman, Mr. Hosseini, who was not even a party to this case, and that it went directly to Uncork for $1 with no revenue tax. And
But there's no dispute that the money came from his client, right?
I don't believe that there is. That never came in because they did not participate with discovery. So none of that came in.
So your best evidence of the gift is that she's not listed on the title. Is there no there's no evidence anywhere that a writings, saying this is a gift, a check that down in the note says gift or anything like that?
Your Honor, you are correct that they did not document well, that there was nothing, written out that would be, we propose to do this and thank you and things of that nature.
But
It
then
was-
doesn't that create a fact issue on whether or not it was a gift? Just solely on that issue alone?
I don't believe so, according to the case law that we cited. So she proffered a gift, it was accepted. Gift happens at the time that it happens, not later. You don't get to rethink it. And one of the main arguments that I used with that is like with the Red Cross. Somebody could make a substantial donation to the Red Cross and then a couple of years down the road say, I don't like what you're doing, what you stand by. I now want my $1 million back. You can't do that. The gift happens at the time it's made.
Right, but wouldn't Red Cross come back and say, and here's our evidence of the gift?
Well, the evidence would be the gift itself. I don't know what else they have. In this case, I know what my client has. And I want to be really clear on something. The plaintiff, the appellant, never did initial disclosures, never conducted discovery. We sent out discovery, it was never answered. I talked to plaintiff's counsel, appellant's counsel at the time. I said, you didn't answer any of my discovery. And he said, And then when I finally filed the MSD is when what came forward. So after the close of discovery is when you saw that information come forward. So this case is unusual for that fact. And then I really wanted to highlight two things that were repeated. The individual, Constancia Hooker, is not a therapist. She's not a licensed therapist. She has never been
But she
trained.
charged for her visits, correct?
Yes, and if you look at their website, they do charge for prayer assistance. This is part of their group. But she did not charge as a licensed therapist, and she is not one and not held to those standards. The other thing is the property is not being used as an Airbnb. They're still trying to turn it into a house of prayer. They don't have the funds. And I think that that's important from the point of view of looking at this. But I want to go back to the complaint for a second, if you will allow me. So then there was the fraud and the breach of fiduciary duty. And then the next count was the equitable estoppel, which is actually a defense. And we even heard one of the other attorneys argue that here before today, that it is not a cause of action, it's actually a defense. But on appeal, they tried to change that to promissory estoppel. So that issue was never before the judge as promissory estoppel.
What's the
That-
difference?
Well, the difference is equitable estoppel would be a defense. It's not an actual cause of action. By promissory estoppel, they're trying to allege that there were almost the same arguments that you make with an engagement ring, that there are promises attached.
What
And-
about counsel's argument that below your client only moved and argued the quiet title action and then didn't address any of the other claims? And then the court, do you dispute what he read into the record here about how sort of short shrift, I believe Judge Reardon said, and that might not be the exact term, but that Judge Gillis gave?
I do dispute that because it was a C8 and a C10 motion. And with the complaint being written like it was and never supported by discovery, I reframed it into two issues: defense of the quiet title, and also how do I explain away all these other issues? They clearly get explained away if you believe my client's argument that it was an unsolicited gift. So that's how we did it. It was before the judges both, and I believe Judge Gillis said when,
And so did he get rid of the quiet title under C8 or C10?
he did not delineate.
Okay.
I don't believe.
And what
'cause
about the other claims then, the other four claims?
The other
C8 or
claims-
C10?
I don't think he delineated under those, because what was important is, plaintiff's counsel actually went back and said, what about the rest of our complaint? And the judge said, for all the other arguments in the motion, those are gone as well. So I had brought it as a C8, C10 to
And-
dispose of everything.
Okay, and attached to your C8/C10 motion, did you attach documents
Yes,
in support of your argument? So
I did.
wouldn't that suggest that it's a C10, right?
yes. And those documents were verification that it was a nonprofit charity, when it was formed. The deed itself,
And why couldn't the court or this court consider what plaintiff attached to their in response to the motion?
Your Honor, what's interesting about that is I originally brought the motion saying that there was no discovery, and then during argument, I waived that part of our argument and said that at that point, let's consider everything that they attached as well, because it actually helped our case, didn't hurt it.
Okay, so there's nothing that, so you concede that below you waive that, so up on appeal, there's no issue with us then considering.
No, that
Those
was waived,
records.
and that was one of the things that if you look at the transcript, one of the things that we discussed that I think influenced the judge was the fact that my clients were not present at the closing, that this was something that happened outside of their scope of involvement. And that's why I allowed the documents to be brought in.
So you just said that attached to your motion, you had the report from Lara indicating your client's corporate status. You attached a quitclaim deed.
Yes.
Plaintiff responds with an affidavit from his client. And then you filed a reply brief. Did you also present an affidavit to provide evidence to the court that it was actually a gift? Because I don't see it. Maybe it's in here and I'm just not seeing it.
I don't believe I did, Your Honor. We were relying on the case law of gift.
Yeah, but what evidence did you present of a gift? You filed a C-10 motion.
Yeah, the deed.
The deed says it was a gift.
Yeah, the
Oh.
deed. And that was our argument, $1 and no revenue tax. So we argued the face of the deed itself, which was basically the only document that we had. And I really want to go back to pointing out all of these facts, none of these were in the lower level. None of these issues came up and were before the court in my MSD. So I believe what the judge was looking at is
About the
if
fact that it was supposed to be a house of prayer.
that was the argument, and that is still the intent. It is still not open as anything else. They didn't have enough money to go forward with that. And
That was discussed in the lower court.
that was discussed. And I believe, Your Honor, where most of the facts came from in this case, is when this first started, I am very big on facilitation. And we actually used a person who was licensed to do religious facilitation for churches. Actually, the head of the Detroit Rescue Mission. We hired him to try to sit down with the parties and resolve this. And that's where I got a sense of most of the facts. And I was rather surprised when no discovery was done to put those forth. But we based it on the deed as it stood, the deed as it was delivered, the deed as it was accepted.
No. Thank you very much.
Thank you.
You have a couple of minutes.
Thank you. Thank you, Your Honor. Try to reply as briefly as I can to the points raised by counsel. I believe she was saying something to the effect that the record showed nothing on our end, obviously ignoring a verified complaint and affidavit and the documents that Ms. McClellan submitted supporting her response. Yeah, it's interesting. She's actually raising arguments today, bringing in new facts that were never mentioned in the court below, such as, oh, it's not, they're still trying to do a ministry. I mean, that's obviously irrelevant. We need to go based upon what took place there. Had they had any interest in challenging Ms. McClellan's claims, in stating, no, we weren't doing this, we weren't pulling the rug out from you, we weren't swindling you, one would have thought an affidavit would have been filed with their motion. It wasn't. They did indeed just purely rely on it being a gift. The deed itself, which they attached to their motion, says nothing about a gift. It's simply a quitclaim deed, I believe, an estate deed to uncorked bill. Now, even their own case law, and I think they relied on a 1929 Pennsylvania case of all things. Even that case, as I indicated in our brief, said something to the effect that you would hold it in trust for the conditions to which it was supposed to be placed. So even if they could, they haven't offered any evidence that it was a gift, purely counsel's arguments, which are irrelevant. They haven't shown anything about gratuitous intent, which is an absolute requirement. Under these circumstances, even if we wanted to misconstrue what the actual record was, if you want to somehow label a gift, at the very least, it would be conditioned on what we've said, possession and control by Ms. McClellan. That by their own case law, they lose in that. They've not cited anything regarding the need for Ms. Hooker to be licensed. She was, in fact, if you look at the law, the law in terms of what a fiduciary is, it's a position of trust and confidence. And again, as you noted, Judge Riordan, she paid her for therapy. And on top of it, she was a spiritual advisor. I think we've shown adequately that those rules apply to her. And the other side continues to argue things that were never argued in court. Again, no part of the motion whatsoever. And
Well, that's what she accuses you of doing too. So.
well, no, look, one could say that Mr. Jensen did not argue all the points that I'm raising. Well, primarily because he wasn't put on notice. Ms. McClellan's entitled to due process. I think that's the reason why Rule 2.116 G4 is in place. He had no obligation to respond to any of that. And I think, as I've indicated in our brief, if we want to look at preservation of issues for appeal, I believe those were preserved. But you could do a de novo review, even if they weren't, in order to prevent manifest injustice and to make sure that this case is properly determined. I think there's neon lights here that would be the case. And then even if you wanted to go down a notch to plain error, I think there's plain error which substantially prejudiced Ms. McClellan all over the place. I believe Ms. Crota made some reference to when the judge was ruling that Mr. Jensen said something which somehow would have, forget her exact verbiage, but in fact, I'm going back again to page 117 of the appendix. Judge Gillis basically said, his ruling was, quote, okay, the ruling of the court is as follows.
Other than Mr. Jensen saying, thank you, Your Honor, I don't think he said anything.
Thank you. That was what I was going to point out.
Okay.
Thank you. So the bottom line is, and again, regarding the discovery, I think you noted that here they said, well, they want to complain that discovery wasn't provided, but then in the reply brief in the court below said, well, we're waiving that because it actually helps us. Well, that's puzzling for a couple of reasons. One, they obviously never filed a motion to compel, and that would be the relief accorded to that. It doesn't really come in on appeal. Number two, that discovery response didn't prejudice them. That was actually attached as an exhibit to their motion for summary disposition, as it was Mr. Jensen's response. And in that discovery response, as we noted, Ms. McClellan denied that it was a gift. So to me, there's just egregious error by the trial court here. The only thing dealt with was the quiet title action. I don't want to repeat all of my arguments. I believe the statute is clear in its face. The title is not required, and it stands on that basis alone. As far as the other counts, they were never noticed up for a hearing, not part of their motion, not addressed by the court. And it would be really manifestly unjust for that part of it to stand. Unless you have any other questions, I thank you for your time.
Any questions?
Questions? Thank you.
Thank you for your time.
Thank you.
All right, take care. Have a good day.
Additional questions?
No, you have no opportunity. Thank you. Have a good day.
Thank you.
That case is submitted. Calling the fifth case on our docket today, case number 369-512, Felicia Scotland versus DTE Energy Corporation Services LLC. Mr. Marco?
Thank you, Your Honor. Good afternoon. May it please the court. John Marco on behalf of the appellant Felicia Scotland, who's here in the courtroom today, along with co-counsel Miss Alice Jennings and Mr. Patrikas. There's been many occasions in my career, and I'll reserve 5 minutes for rebuttal. There's been many occasions in my career where this court's told me I've been wrong. The last time Judge Treblecock, I think he convinced 3 judges. He was on the other side of the bench, but convinced 3 judges that I was wrong. And Judge Roden, you've told me before that I was wrong. And
I think I told you you've been right too.
You have, Your Honor. To be fair.
Yeah, let's be fair about this.
You have, Your Honor. You have. The point is, it was a fair fight. And we may have disagreements and we may disagree or see things differently, or my arguments may not take the day, but it was a fair fight. This was not a fair fight. This was a fixed fight. And it's not just me saying that, and I don't say that lightly. I've never said that in my career, but Wayne County jurors who had no bias, no exposure, no.
I know you put the affidavits in with the jurors there, but judges are entitled to say things, and you don't remove a judge just because you don't like her rulings.
Absolutely. This went beyond just not liking the rulings. This was bias that infected the proceedings below. And the jurors said that. I mean, rolling of the eyes, and let's just go procedurally what happened. So we have an understanding of this, because
it's pretty well spelled out. I read it. And I know Judge Hubbard. I don't know her personally. I don't think I've ever met her, but I've seen her work on this court, and I've read transcripts with her before. So
I understand.
I'm familiar with it.
And you're probably more familiar with her than I am through your exposure up here on the appellate courts. I want to talk about this case and what happened here. That's why we're here, and how we did not get a fair chance to litigate this case.
Mr. Marco, let me ask you, what I really want to hone in on, or the question that comes to me is, so you lost on everything but retaliation. You're going to trial on retaliation.
Yes, Your Honor.
And then, you document what occurred and the mistrial and all of those.
Yes, Your Honor.
things. Why did the court get it wrong when it subsequently dismissed the retaliation claim?
Yes. So let me address, let me hit the retaliation claim. So November 16th of 2022, they filed their motion to dismiss. Judge Hubbard partially grants it, but says there's a question of fact for the jury on the retaliation claim, right? So we're proceeding as scheduled. They file a motion for reconsideration. Judge Hubbard, a second time in a written opinion, denies the retaliation claim. I enter an appearance as trial counsel because we're getting close to trial. I'm getting ready for trial. There's all kind of motion practice regarding what evidence comes in or what evidence does not come in. We get to the final day of trial. You're right. It's the retaliation count. But the timing is important of how this occurred, Judge Treblecock. So we go through the trial process, which I've outlined, where she's rolling her eyes during my voir dire. By the way, no objection. There's no objection at all during the proceedings.
I understand all that.
Okay.
I get all that. I want to get to the substance
All right.
of why. I don't care when
All right.
if she would have granted it back when Mr. Watson first filed it.
Understood. So
Why would it have been wrong there? Because the facts didn't change, right? The
facts didn't change. There
changed
was
between when it was first filed and then when it was granted.
There was no new evidence that came in. The only thing that happened was my opening argument, which was cut short in the middle. There was no request by defense to reexamine the retaliation
Right,
claim.
but let's get.
Okay, okay.
Get
So,
past all that and tell me why she was
all right,
wrong.
so let's look at the timeline here. So we have the timeline of facts as it relates to the retaliation claim. So Ms. Scotland is working at DT for 20 plus years. She's an exemplary employee. She begins protected activity, specifically that would trigger retaliation protections. What's the protected activity? Number one, she makes internal discrimination complaints to her supervisors, multiple.
And when were those in relationship to the termination? Weren't those many years prior?
There was a myriad of complaints many years prior, but that was protected activity. That's not our strongest protected activity because the timeline gets better for us. After that, she escalated those to HR. Then there was a civil rights complaint that was filed by Ms. Jennings. The civil rights complaint was filed on January 31st of 2020. That's protected activity. It's under the statute. That's undisputed. The Elliott Larson Civil Rights Act states 37.2701. Here's what's protected. You make an internal complaint, that's protected. You file it Elliott Larson complaint, that's protected, obviously. You testify, that's protected. You participate in a lawsuit is protected. That's specifically under the act, under subsection A.
Why does the company's reason, why is that pretext? Get to that. Like,
Yeah,
why,
yeah.
why is that a pretext? Because
So-
it seems to me what they said is, look, she took internal documents, she gave them to a third party. Now it was her attorney, and I know you have
Yes.
all those arguments, but
Yeah,
so DTE's position is employee took internal documents clearly prohibited by our policy. She's signed and acknowledged our policy. She's a long-term employee. She knows our policy, and we fired other people for violating the same policy. Tell me why that is.
yes. So
Shut.
a company's policy doesn't trump statute or the Constitution. So they can't have a policy that says we're going to fire the Catholics or we're going to fire the blacks. That's clear. Their policy gives way to protected activity under the act, which is an act that's in the Constitution. And we cited the case law on that.
Why is taking internal company documents and giving them to a third party or even your attorney, why is that protected activity? Why is that not just a clear case of misconduct?
The case law, there's no Michigan case that's directly on point dealing with this. But the case law from the federal courts is clear that it can be protected activity. You have to be able to give your attorney documents. It's worse here because of the following. They sent her discovery requests that say, give us the documents. This was not a locked up document. She didn't go rifling through her supervisor's cabinets. This was a document that was saved on the system that she also had a copy sitting right on her desk.
That's a proprietary system though, isn't it? You have stuff in your office that the cleaning people go through well, you're in your office, they could grab something off the desk, say it was on a system and it was there and I'm going to produce it.
In that type of case, then they would have a strong argument that that was not protected. The case law doesn't support that here. If one of my employees sees if I haven't sent out an internal memo that supports an Elliott Larson Civil Rights Act claim or a whistleblower claim, and one of my attorneys takes that document and says, I believe that this is wrong, then there's a lawsuit on top of that. And I say, your case should be dismissed. I then ask them for the documents to support their case. They take the document that's on their desk and provide it under a protective order to only their attorney, who then uses it in the litigation under a protective order without disseminating it outside. That is protected activity. That is, it's under the statute that it's protected, and it's under the federal case law interpreting the statute. They cannot cite a single case that says that that is not protected activity.
How is it? Under the plain language of the statute, I struggle to see that it's protected activity to take proprietary information and provide it to a third party. Now, what you would say, what you would want, if I understand you correctly, you would want us to read into the statute saying, unless that proprietary information helps your lawsuit and you give it to your attorney in a case where there's a protective order.
So,
Is that the standard? we're to
no,
adopt?
so respectfully, Judge Tribulcock, the case law says you're wrong. Okay,
Which case?
we can start with the Niswander, which is a Sixth Circuit case.
Why don't you do that? Why don't you go through the 6 factors in this wander and tell us how to
Yeah,
apply it?
let's talk about the factors that are outlined. So Niswander specifically says that, quote, an individual's delivery of relevant documents during the discovery process or the giving of testimony at a deposition falls within the ambit of, quote, participating in any manner in a Title VII proceeding. Elliott Larson uses the same language. It prohibits retaliation for someone proceeding in any manner in an Elliott Larson Civil Rights Act proceeding. Niswander specifically says that if, quote, if the documents that the plaintiff had given to her lawyers had been directly or even indirectly relevant to the claims raised in the lawsuit, her delivery of those documents would clearly constitute participation in the lawsuit, and therefore it would be protected activity. So you can't have a pending civil rights lawsuit, have the defendant ask for particular documents. The person has immediate access to those documents. They give them to their attorney only under a protective order, and then they fire the individual. It violates the language of the statute, and it violates at least federal case law interpreting the statute.
So would you agree that that case and that standard doesn't go as far as to all cases of misconduct? There's no blanket rule that says, look, there's going to be a fact issue anytime a company fires somebody who's got a lawsuit pending for misconduct, is there?
No, you have to do an analysis of the
For the
factors.
factors.
And look at Quinlan. Because look, this has never been decided by me. I would urge this court to adopt the Quinlan decision, Quinlan, which is the Supreme Court of New Jersey, which relies on the Niswander decision. Niswander's good. I think Quinlan's Niswander plus. Okay. Here's what they say. And because New Jersey has an anti-discrimination statute, much like Elliott Larson's Civil Rights Act statute. And it's very similar. And this is what they said. This is on page 268. We begin with the observation that the Niswander test comes close to capturing the essential elements that must be considered in balancing the rights of employees and employers. We conclude that it should be expanded in two ways. First, the elements in Niswander must be fleshed out to provide better guidance to our courts, which they then go ahead and do. And then they say, second, that in the end, our act is a little bit different than Title VII, and we must advance our act's strong remedial purpose as it seeks to carefully balance legitimate business interests of employers against the means and methods used by employees. So to your point, if she had taken a document that had nothing to do with this case, if she had went in a place she shouldn't have went in, if she had rifled through her supervisor's cabinets, if she had then published that outside of this lawsuit or done things under the totality of circumstances case, they would have a pretty good argument that that's not protected and that she can't rely on that. That is a far cry from what happened here. In this case, she was obligated pursuant to the discovery rules to provide them with that document. This $10 million tax error was a critical part of this case. It was brought up at every single hearing, at every critical juncture. It was brought up early and often. And they said, give us documents that show that this actually happened, because they didn't admit early on that this actually occurred. So her attorney, Ms. Jennings, told her, we have to provide these discovery responses to add protection for them. On November 6th of October 2nd of 2020, they request these documents. A month later, just over a month later, on November 6th, Ms. Jennings agrees to a protective order for all DTE proprietary and confidential documents. And this was in a public tax return. Ultimately, these were some of the notes that led to that. Arguably, and I argue, it's not even confidential. This wasn't like state secrets. This didn't show the nuclear reactor or anything. This was their calculations on a public tax filing. But assuming that it's confidential, Ms. Jennings said, fine, we have a protective order. A deposition then occurs, and she gives the document to them on January 26th. They fire 6 days later. If you look at the factors, which I think this court should adopt Quinlan, or if you don't agree with me, which
Should that record been produced in response to discovery prior to the deposition?
it was rolling supplemental discovery. You know how this goes. In an employment case, there's sometimes thousands of pages of documents that are produced. Ms. Jennings started producing documents as they became available. As she's preparing for the deposition, this document becomes available and she doesn't hide it. She produces it to the opposing party. There was no clandestine activity here. They asked for a document. The document was on her desk. The document was not in some system that was locked down. She gave the document to her attorney only under protective order. And as she was required to do pursuant to the court rules, and her attorney gave it to DTE in a deposition and did not publish it to a third party.
That's why I actually think Niswander is better for you, because the very first factor in Niswander, according to that court, it says that if the plaintiff obtained the document pursuant to her regular business with the defendant, as opposed to going through the system and searching for it, then that factor weighs in favor of the plaintiff.
Yes.
And then you can go on with all 6 factors.
Yes.
It's very similar. They seem to be suggesting that the plaintiff in that case, who did kind of the opposite of what your client did, that the plaintiff in that case does not get get relief. But that someone in your situation would have most of these factors weighed in their favor.
All the factors here favor Miss Scotland.
Not all of them.
Well, see, I said we can disagree, and that's fine and that's fair. But if you look at them, the second, what did the employee do with the document? This is from Quinlan, which is citing Niswander.
I mean, we could at least agree that the fifth factor, which is the scope of the employer's privacy policy, that factor weighs in favor of the defendant. They had a pretty wide policy, did they not?
It does, but that's why we had a protective order agreed to. So there's no, there was a protective order.
Was the protective order agreed to after plaintiff had already taken the document, or was it before?
No, the protective order was agreed to on November 6th of 2020 through an email by Ms. Jennings.
Okay, when was the document taken from her desk?
The document was taken from her desk after that time because it was produced shortly after Ms. Jennings received it on January 26th of 2021. So they sent.
Is that relevant to our inquiry in terms of if we're to adopt a test? Is there a factor that we should be considering about, the conduct or the intent of how it was produced? And
Yeah,
how it was handled?
that's one of the factors. What did the employee do with it? Here's what they say. Can I just read you? This is from Quinlan. They say, look, the court should evaluate what the employee did with the document. If the employee looked at it, copied it, and shared it with an attorney for the purposes of evaluating whether the employee had a viable cause of action, or in assisting with the prosecution of the claim, this factor will favor the employee. If, on the other hand, the employee copies a document, disseminates it to other employees not privileged to see it in the ordinary course of their duties, or to others outside of the company, this factor will balance the employer. So, yeah, it deals with these concerns. This test deals with these concerns. If we had a case where she took a document that was confidential, she went out and she gave it to the Detroit Free Press, and it had nothing to do with the underlying claims, they would have a much better argument on this. But under these circumstances, if you apply this test, if you look at the statutory language, how could this not be protected? And what the trial court did in this case was she ignored it. She didn't even deal with it. She ignored the document. She ignored other protected activity. She acted like it wasn't there, and she never addressed the issue. But I've been saying from the moment I was involved in this case, this is a very easy case. They admit that they fired her for taking this document. They requested this document in discovery. She gave it to them legally and ethically. Okay. And that should end the.
Did you give them the document twice in discovery and then also during the deposition? Or are you calling the production during the deposition being the document produced during discovery?
Given it during the deposition.
Okay.
Which happens. I mean, and it especially happens in employment cases when you have thousands of pages of documents. And it especially happens when a plaintiff's attorney or a defense attorney is preparing for a deposition. And this was a supplemental disclosure.
Yeah, go ahead. I'm sorry. I cut you off. Go ahead.
No, it's okay.
I guess where I struggle is with the Elliott Larson Civil Rights Act and what the plain language of the statute is, that you're asking us to read in that protected activity, the definition of protected activity is broad enough to encompass conduct which plainly violates an employer's policy.
Well,
And to do that, we'd rely on the Niswander factors.
yeah,
That's what you're asking us to adopt.
I'm asking you to adopt the Quinlan factors, which is Niswander plus. But if you disagree with me, I think the Niswander factors from the Sixth Circuit are perfectly reasonable. I think that Quinlan just expounds on them a little bit. But a policy, their internal policy does not control. The statute and the Constitution controls. Elliott Larson Civil Rights Act is a creature of the Michigan Constitution in 1963. There was a mandate that our legislature pass legislation. It was bipartisan bill that was passed to conform to the Constitution. That's what controls. This court said it time and time again. Our Supreme Court has said it time and time again. They just said it in Rayford, which just came down this year, where they said that the court has to look if a company puts in a statute of limitations to bring a claim in Rayford, the Michigan Supreme Court just remanded to this court for a determination of a whole host of cases that you're going to be seeing to see if it complies with good conscience and if there's traditional contract offenses. They cannot write a policy.
But doesn't, I guess that leads you down a rabbit hole that says, look, if their policy it isn't her acknowledgement in a separate agreement says as a condition of my employment, I'm agreeing as a matter of contract to abide by these policies.
No. What if you had an employer, here's a policy. You're never going to sue us. We can discriminate you. We can call you an N-word. We can discriminate based on your religion. We can discriminate based on this, but you're never going to sue us. That's an invalid policy. It conflicts with our Constitution and it conflicts with the statute. How about another policy? You're not entitled to take vacation time, which is a violation of.
Okay, so I get all your extremes and the sky is falling, but in this case, the law recognizes that individuals and companies have a interest to protect their proprietary information, which can be broadly defined both under common law and the Uniform Trade Secrets Act. And if they've got a policy that protects that information and an employee violates that information, that policy that they've agreed to, I understand the reasons in Ms. Wander is applying Ms. Wander's factors, or as you wanted, the Quinlan factors plus that is also constitutes protected activity if you satisfy those factors.
It does because a company.
Even if it's a violation of policy.
It doesn't matter. I respectfully disagree with you with this idea that they can write a policy that controls litigation and that would somehow trump the Constitution and the statute. Their policy can be considered. And again, this is why we go back to the balancing test. The courts say, including it's in our statute, but the federal courts that have interpreting a very similar statute say there has to be a balancing test between the employer and between the employee. Again, you take the nuclear plant schematics and you go give it to the public and you let a competitor use it, we're not going to be here. Okay.
Really, we're talking about one element of your claim, because there was already alleged protected activity that occurred prior to this. This is
There was, but this is
part of the damages. This really goes to damages.
It does not. There was a lot of protected activity here, but this was the closest in time. And they're arguing, well, this was, look at these things, as you asked, didn't those complaints happen far away? Yeah, they did. Our case, our best case is she did what they asked. She took a document, gave it to her attorney under protective order. She had a legal right to do that under the case law. Her attorney advised her that she had a legal right to do that. The case law is at least the federal law. I agree this court has not passed on the issue, but this court would have to ignore the statutory language and ignore a wide berth of federal case law. That's a well-reasoned, moderate approach. This is not Niswander wasn't some outlying opinion. I mean, they tried to balance and say, in this case. So I understand your concerns, but that's not this case.
Getting close to your time, very close.
Yes,
So you might want to
understood.
Say something for rebuttal.
So I would ask, I would pray that this court does remand and reverse the trial court, but I also would ask that we be assigned to a different judge. I know that's not something that this court takes lightly. I do not believe that we can have I haven't went over all the evidentiary errors and everything else.
Don't have time to, so
But
it's.
I understand, but there was, there was a motion to disqualify following the thing, and
Okay,
I
you want,
received
you
a-
want time for rebuttal or not?
Yes, Judge.
Okay. Give you a couple of minutes, Mr. Marco, okay? Okay.
Good afternoon, Your Honors. My name is Jerome Watson. I haven't appeared before this court in years, and I don't know if it's going to be my last appearance or not. It might be, but I'll tell you, I'm happy to be here today.
We're happy to have you here.
Thank you. I represent DTE, And our position in this case is that summary disposition, complete summary disposition as to all of the plaintiff's claims was properly granted. It took the judge a while to get there, but she got to the right decision. This is a little different case than the standard employment matter. Plaintiff filed suit in January 2020 while she was still employed at DTE. She asserted 5 separate claims: hostile work environment, retaliation, harassment, race, age, and gender discrimination, and being denied 4 separate positions, and also discrimination because she got a substandard evaluation. We call those the pre-termination claims. 1 year and 1 day after that complaint was filed, plaintiff was terminated. As a result of that termination, she amended her complaint, asserting 2 additional claims: discriminatory termination, claiming that because she filed that complaint, she was discriminated against, eventually terminated, and retaliatory termination, claiming that DTE, because she filed that complaint, retaliated against her by terminating her employment. In this argument, I want to focus on the 3 claims: discriminatory termination, retaliatory termination, and hostile work environment. First, retaliatory and discriminatory termination. We submit that those claims should primarily be based on events that took place from the time she filed her complaint, January 31st, 2020, to the time she was terminated, February 1st, 2021, a period of 1 year and 1 day. What happened during that period? Well, during that period, virtually nothing happened to benefit the plaintiff. She was not written up. She was not criticized. She did not get a poor evaluation. No one shouted at her or did anything to her. Nothing negative happened to her during that 1 year and 1 day period. What did happen? She was placed on a performance improvement plan because of a substandard 2019 evaluation. Under the DTE process, when an employee is on a performance improvement plan, the supervisor delineates the various areas of weakness in the employee's performance and provides goals and activities the employee should do to address those weaknesses. Plus, the supervisor meets with the employee weekly for 13 weeks to address the employment deficiencies. That's what happened here. For 13 weeks in 2020, the supervisor met with Ms. Scotland to go over her performance difficulties. At the end of that period, in November 2020, the supervisor, Mr. Terry Yee, submitted his evaluation indicating that she'd fully achieved every single one of the 5 deficiencies he's listed in her performance. And at the end of his evaluation, and I started to bring it to read it, but at the end of his evaluation, he said plaintiff had done a very good job in addressing deficiencies. She was performing well with her experience and dedication. He had no doubt that she would continue to do well in her DTE employment. That's what was going on in 2020. Well, why was she fired? Her termination was solely due to what happened that was revealed at the deposition of a coworker, Scott Ashlock, which deposition took place January 26, 2021. In that deposition, plaintiff's attorney produced a 3-page confidential DTE document, an audit adjustment form that DTE would submit to the Internal Revenue Service to address an issue that DTE had in a previous tax return. This audit adjustment form was submitted to IRS in 2017 to address an error in a DTE return made in 2016.
Mr. Watson, we, as you heard, we grilled Mr. Marco quite a bit on retaliation. Why, what's your take on whether we should, you heard him argue quite adamantly and persuasively, you know, Niswander, we ought to adopt Niswander and
I heard it
Quinlan. Why is he wrong?
because he's dead wrong. Niswander and Quinlan in Verland. I always want to say Verlander, it's Verlager or something.
He's on San Francisco.
Those cases do not support them at all. The overall test, although each case has a slightly different test, the overall test is whether plaintiff, under the totality of the circumstances, acted reasonably in utilizing a self-help remedy. In this case, for at least 4 separate reasons, plaintiffs and her attorney's actions were anything but
Well,
reasonable.
before you go into that, are you telling us we shouldn't adopt one of those tests or that we should, and that utilizing that test, your client still wins? Which of
I
those two
think
tracks are you going down?
utilizing the totality of the circumstances test, the client wins. Reading the Niswander and Quinlan cases and interpreting them with the facts of this matter, DTE still wins. Plaintiff's actions were unreasonable for at least 4 reasons. Plaintiff's attorney talks about the request for production of documents and how DTE requested the very document that they fired plaintiff for turning over to her. The fact of the matter is, in October 2020, DTE filed document requests requesting all forms and documents supporting plaintiff's claims. It did not identify the audit adjustment form. It asked for documents supporting plaintiff's claims. That same month, October 2020, plaintiff, however, filed specific document requests seeking all audit adjustment documents from 2016 to present, whether or not those audit adjustment documents were filed with IRS. She was the one specifically requesting that DTE produce the form, which leads us to conclude she already had the form. And as an aside, this wasn't a document she had in the regular course of her business. She wasn't working on the tax return for which that document was relevant. She had nothing to do with that tax return. But anyway,
Wasn't she the one that found the error in the first place?
she says she did, and we dispute that. That wasn't her tax return.
But
She
wouldn't
wasn't-
that document been part of the meeting that they had that was discussed, you know, at length in the briefs, the meeting where she was allegedly pushed into a wall? Wouldn't that document have been part of that discussion? And
She claims that we dispute that. We don't think it was.
so that meeting never happened.
We think a meeting happened at that date, and I'll get into that, but we don't think that document came up at that particular meeting. But anyway, the 4 reasons why her actions were unreasonable. Both parties requested documents. DTE responded to plaintiff's document requests in November 2020 by saying these audit adjustment forms are irrelevant to this dispute. And also they're confidential, sensitive information. DTE refused to produce it. Plaintiff responded to DTE's document request for all documents supporting her claim by producing documents, but did not produce the audit adjustment form. We think she had it. She didn't produce it. She saved it to spring on Ashlock at his deposition. That was unreasonable, number 1. Number 2, we feel it was her actions were unreasonable because they violated DTE policies. We're not saying that if plaintiff had a document and turning it over to her attorney for use in a deposition could not be protected activity. However, her accessing a confidential DTE document is not protected activity. It violated DTE policy, 2 clear DTE policies, and the penalty for those violations could be discipline up to and including discharge. And in fact, in some of the cases cited by the parties, the courts have said that if plaintiff in taking a document violates company rules, the plaintiff can be appropriately disciplined.
So during the discovery or investigation supporting the termination, what, is it part of the record how she came in possession of the document? Has that ever been discovered?
I don't think it is. Everyone just assumes that she took it from the tax department database. Which brings me to unreasonable action number 3. The tax department has a database of hundreds of thousands of documents, Many of them are extremely confidential and sensitive, not only in regard to DTE, but in regard to DTE's business partners. How are those documents protected? The only protection for those documents is the honor system. Every professional employee in the tax department has access to the entire database, all of the hundreds of thousands of pages of documents, but they're instructed and they know that they're only supposed to access documents for DTE's business use, not for their personal use. She accessed the document for her personal use, which violated the DTE honor system, and it was an unreasonable action. We submitted the affidavit of Patrick Lee, the director of the tax department, and he goes on at length at how important it is for DTE to maintain the confidentiality of those documents and how plaintiff's breach of that honor system was the first one that he's aware of by a DTE employee.
So based on what you're telling us here, it sounds like you're telling us there's some evidence in the record that rebuts the plaintiff's deposition testimony where she said that she found the error. So can you help me out and point me to where in the record, who did actually find that error, and where do I find that? Is that in another, the deposition transcript?
It's never really been identified. Scott Ashlock, Mr. Director Lee thought Ashlock might have found the error. Ashlock couldn't recall. Lee wasn't sure who found the error, but it would be almost nonsensical for plaintiff to have found an error on a tax return that she never worked on. We just don't buy that at all, but it's not been, as far as I know, it's just not been identified in the record. And finally,
Sounds like something he would have remembered if he found it, a $10 million error that he himself made.
could have been technically, the error was not quite so egregious because KPMG made the error on the tax return. It was Mr. Ashlock's tax return to review. And he reviewed it, didn't catch KPMG's error. So his error was not catching KPMG's error, which was a mistake, no doubt. But a mistake is a far cry from intentionally violating company policy. The fourth unreasonable action was again taking the document, which violated two clear DTE policies. And I forgot to mention perhaps the most unreasonable action. DTE objected to producing the document. And that objection hadn't been decided. The court appointed a special master to determine various discovery disputes. Pending before the special master was DTE's objection that that document should not be produced for various reasons. At the time of the deposition, plaintiff's attorney jumped the gun, produced the document anyway, when the special master had not made a decision. We submit that was very unreasonable. It probably violated the court rules, if not the letter of the court rule, the spirit. While a decision is pending before a court, you just can't forge ahead and utilize the document in a deposition. And it might have been violative of the code of ethics, in our opinion. But anyway, for those 4 reasons, the document, plaintiff's actions, I should say, were unreasonable. And under the totality of the circumstances, her actions were not protected activity. Plaintiff forwards other reasons why she should be able to expand the ambit of this dispute. For one thing, she claims that, let me look here. Oh, there are other reasons she claims that she ought to be able to use the evidence. For one thing, she claims that she ought to be able to go back to the pre-termination claims and use evidence from those claims in her, for her retaliatory termination claim. She says, well, evidence from those prior claims is relevant for background information in the termination claims. We submit that that's improper. It's improper because this case consists almost of 2 separate cases. The pre-termination claims were everything up to the time of the complaint, and the termination claims started with the complaint and went to the time of termination. What happened before the complaint was filed has very little relevance to what happened in regard to the termination claims. That relevant period was after the complaint was filed. And therefore, she should not be able to go back and use that pre-termination evidence. In addition to that, she's claiming that, well, if I were able to use that evidence, I could create a fact question. There are several cases that say that you can use evidence from dismissed cases to provide background information or context information on claims that have not been dismissed. But that background or context information cannot carry the day. Sort of like, where's the beef? If she wants to prove retaliation or discrimination, she's got to come up with statements, documents, facts, suspicious circumstances, something over that 1 year and 1 day period.
So where are we to draw the line in terms of what background or context should come in? And where do we draw the line, or is it for the jury to let it all come in and let the jury sort it out?
What the courts have done is say that background or context information can come in on a limited basis, and the court has decided how that could be done. What Judge Hubbard did was she said that plaintiff could introduce evidence that she'd asserted claims, these pre-termination claims, hostile work environment, retaliation. She could say she asserted those, but not get into the substance of any of the claims, and certainly not say that a coworker shoved plaintiff into a wall. She couldn't say that.
So to state it differently, she could introduce evidence that she had made prior complaints of misconduct or discrimination or harassment, but that was
it.
That was it.
And
And
then-
couldn't get into all the factors behind it.
Right.
At some point, did your client move to redact the version of the complaint that was going to be admitted as an exhibit to remove those references?
No, we didn't. What I assumed the court would do would be to allow plaintiff to introduce the complaint, and that would be it. It would be an exhibit. There could be no testimony about the specific incidents in the complaint.
But if it's admitted as an exhibit, isn't it fair for either counsel involved to, go through that exhibit during both the opening and the closing?
I don't think during the opening because it hadn't been admitted, but during the closing, it could be fair game. But I
Hadn't she
plan,
just ruled that she was going to admit it?
she ruled that she would admit it, but she also ruled that you couldn't get into any of the substance of it What I planned to do was during the trial to tell the court, look, he cannot read or do anything with the complaint, and we should be able to redact all the factual stuff. Really nothing. She said he could do nothing other than introduce the claim, say that she'd made the claim so that
Was
we
there,
didn't like the
was there an
decision.
objection made at the time of the opening that he couldn't read from the exhibit because it was opening statement, it hadn't
I
been
did
admitted yet?
object. They say I didn't. I did object. I objected on the basis that he was getting into the facts.
No, I mean, earlier you said he couldn't get it in through the opening because it's not technically admitted until you put in your proofs. So the question is, did you make that objection in the opening?
No, I didn't. I objected when he got into the facts of it and said he couldn't get into that, as the court had clearly stated. And the judge just said something to the effect of, we've already covered this, which now, as I read it, meant plaintiff's attorney should have known that he couldn't get into that, but he continued to go into it. To get back to my argument as to retaliation, 3 reasons that we were entitled to summary judgment on the retaliatory termination claim. No evidence of a causal connection, none whatsoever. No evidence that the reason we'd given for terminating her, the use of that confidential document or her accessing the confidential document was a pretext for retaliation, and that her utilizing that confidential document, her taking that confidential document was an intervening cause for her termination. And as an intervening cause, it basically trounced or wiped out any inference that could be gleaned from her filing the complaint. Similarly, in the discriminatory termination claim for that 1 year and 1 day period, there was no evidence of discrimination, no documents, statements, absolutely nothing. No evidence that the reason we gave for the termination was pretext. And also the intervening cause of her accessing confidential document and using it resulted in wiping out any inference that by filing the complaint, she was retaliated against. So summary judgment on those 2 areas was appropriate. In the final claim I want to talk about is the hostile work environment claim. Plaintiff, as far as the pre-retaliation claims, seems to have pretty much abandoned most of those claims. And to the extent she didn't abandon them, we'll stand on our briefs. But she does really say a lot about the hostile work environment claim. And what she said is that the DTE coworker pushed her up against the wall, up against the whiteboard, fairly violently in the presence of the supervisor, and the supervisor did nothing about it, and DTE did nothing about it. If that were indeed the case, wouldn't that, according to plaintiff, satisfy the severe or pervasive standard that she has to establish to prevail on a hostile work environment claim? At a minimum, wouldn't that create a fact question as to severe harassment? So that's their position. And it causes one to think, what was Judge Hubbard thinking when she granted summary disposition on the hostile work environment claim? Well, we've got 4 things which Judge Hubbard might have been thinking. For one thing, Judge Hubbard might not have relied upon what plaintiff's counsel said, plaintiff said in her deposition, and instead relied on the deposition. And plaintiff cites portions of her deposition at page 11 of her appeal brief. And in regard to the incident at the whiteboard in which plaintiff claims she was shoved, plaintiff describes how the coworker Ashlock and the supervisor Yee were discussing an error Ashlock had made. Plaintiff was sitting at her desk. She wanted to be part of that conversation, so she sought to join it. And in her deposition, she says, and then when I got up to squeeze past him so I could see the board, it was a tight space. She was sitting. She got up to squeeze past Ashlock so she could see the whiteboard. And the three of them had a conversation about the error. But then when the conversation ended, Ashlock had to go back to a seat. And plaintiff describes that. She said, so he pushed by me to go back to his own desk, knocking me into the wall. She didn't say he shoved her. She said in this tight space, he pushed by her. Was her squeezing by him more serious than his pushing by her? Could have been, but that's a factor the judge considered. But 150 pages earlier in the deposition, when she first talked about the incident, she gave different testimony. On page 115 of her deposition, she was asked about it. Question, okay, and when you say he's put his hands on you, how many times has that happened? Answer, well, it happened once. Question, okay. Answer, and he never touched me. Actually, just kind of blocked me out. So she admitted in her deposition that he never touched her until she changed her testimony. Certainly, Judge Hubbard would have heard that.
So counsel, let me ask you, going back how that, I just want to make sure I have the understanding of the facts. The error they're talking about, that where she tried to get in on the meeting and the alleged physical contact between the two occurred, is that the $10 million error?
We don't think it was. Neither Lee or Ashlock thought it was, but plaintiff says it was. And maybe for purposes of this, you have to assume it is.
But, okay, but you admit, that DT admits that and didn't challenge that the meeting that took place was to discuss some error by Ashlock.
Actually, Ashlock and Yee weren't really sure what the meeting was about.
But there was a meeting, they recall that she came into the meeting.
They seem to recall there was a meeting and she got up from her desk to enter into the meeting. They couldn't recall exactly what the meeting was about, but we think that was the one where possibly there was the contact between the two of them. Although in her deposition at one point, she said there was no contact. So Hubbard could have considered that. Hubbard also could have considered the fact that that
You have 2
alleged,
minutes left. You
2
still have
minutes, the alleged meeting took place on March.
According to my calculations, sorry.
Okay, the alleged meeting took place on March 29th. March 30, she talked to her director about it. And according to the director, in a memo he sent to HR and also his deposition, he said he'd asked her about the incident. He thought there could have been a bump, nothing more serious than that. She said she wasn't fearful for her safety. She said she didn't want him to go to HR. He thought the issue was a personality conflict. So that happened. And then finally, in 2019, the incident occurred in 2017. Plaintiff in her complaint says it was in September of 2017. It took place March 29th, 2017. In 2019, she got around to filing an internal complaint about the incident. And that internal complaint was fully investigated and plaintiff's claims were unsubstantiated. The decision was against her. And the court relied upon that in the fact that it took her 2 years to file the internal complaint, a year after she'd gotten an attorney. She got an attorney to help her in the matter in 2018. And considering all those factors, the court concluded that that wasn't severe pervasive harassment, not even a fact question. She had a lot of lesser things, like a supervisor shouted at her, someone closed the elevator door in her face. She says someone shut the door as they left the
You're gonna have to wrap it
conference room.
up. To be fair, 30 minutes.
And none of that constituted severe pervasive harassment. And the final point, Your Honors, is that the judge ruled that she did not tie any of her harassment into race or age or gender. She didn't connect it. She came up with a lot of different incidents, but she didn't connect it to any protected classification, which is the reason for denying her claim. Thank you.
Okay, thank you.
Thank you.
I'd like to clarify, Judge Wallace, you asked about the complaint. The complaint was in evidence because we had a joint final pretrial. We hashed out all the evidentiary issues about what was going to be admitted, what was not going to be admitted. And then they were admitted prior to me beginning my opening statement, so I could use them exactly so this would not happen. And there was no objection. He said, he just told you there's an objection. Read the transcript. They never objected to me using.
I think he said that his objection wasn't noted, but he made one.
Well, it wasn't made. There's no record of it. You're not going to see it. I was there and I read the transcript. There's no objection whatsoever. It was an admitted exhibit. And in fact, he did the opposite. Look at page 28 of my brief, which cites the trial transcript, page 43. The judge asked him, because she said, what are you doing? I said, I'm showing him exhibit 1. It's admitted into evidence. That's me. Defense attorney, quote, my recollection is you said the complaint could be an exhibit. The court, yes. Me, this is an exhibit that's in evidence. That is what the record is, and that's the reality of what happened. This was in evidence. It was not objected to. And the reason it wasn't objected to is because they knew that according to the rulings that she had made, I was allowed to show it and talk about it. This idea, I've never heard of this. There's an admitted exhibit that is no request for redaction, and I'm not allowed to show it to the jury or talk about it. It's a hidden exhibit. It's a secret exhibit. That is not in the court rules. That is not in my understanding of any trial procedure whatsoever. With regard to the hostile work environment, we'll rely on my brief, but I want to point this out, this pushing. There's a transcript of her. There's a recording of her complaining to her direct supervisor. He pushed me. What are you going to do about it? And that's exhibit 17 in our reply brief, where there's a recording at work of her complaining to her supervisor. She also made an HR complaint to DTE that we weren't allowed to put in, where she complained specifically to human resources. He physically assaulted me at work. She was told Black people aren't good accountants. Your son shouldn't be an accountant. And this is the only Black woman in the entire department, by the way. Your son shouldn't go into it because Black people don't make accountants. Black employees were referred to as DA, dumbasses. They were called lazy. She was told that she smelled. And then we have the physical assault and then everything else that I outlined in my brief. It's a question of fact for the jury. Finally, I would rely with regards to this concern from Judge Triblecock about, balancing this interest. I really encourage you to read the Quinlan decision. They talk a lot about business interests and how businesses do have a legitimate interest in trade secrets. Businesses do have a legitimate interest in enforcing their policies, but there has to be a give between a constitutional statutory provision and policies. This is a case where she was entitled under a protective order to give her attorney a document that was not confidential, by the way.
Help me then so that we can adequately balance it. Why is that document so key? Why was it so important that if you believe DT, she stole this document and ran it to her attorney and her attorney springs it in the deposition?
Yeah.
Why is that document so important?
Because
Help me understand
as you
that.
heard from the defense this morning, everybody forgot everything. We don't remember a meeting. We don't remember you getting pushed at the whiteboard. We don't even know who found the tax error. Remember, they just said that. That's what they were going to tell the jury. We don't really know, but we don't have any evidence refuting it, but we don't really know. I have to prove my case. When I don't prove my case, you guys tell me or the trial court tells me, and the case goes by.
So,
Right?
so is the tax error important to establish that the meeting took place and that's where she was bumped? Is that why the document's important, or is it important for some other reason?
The tax error was a key moment in the case where she finds this tax error of a young, white, brand new employee who makes a $10 million tax error, and he's not punished for it. The DTE doesn't punish $10 million. Okay, and it's submitted. They had to file an amendment, Your Honor. So this was actually submitted to the IRS. It was a bad tax return. She finds the tax return. She brings it to management's attention that this guy made a $10 million error, and you just affirmed it to the federal government. It begins this whole hoopla of having to unwind it and bring it back. So, and this guy suffered no repercussions. There was no discipline whatsoever. And they're going to say she's fired because she gave a document that was already provided to the IRS. This wasn't a secret document.
Hey, you got a minute left.
Yeah, I guess my question is, I get all that, but I guess why was that document, was she disciplined for making similar errors? Or was that document important to just show another guy in her department made a big error and no discipline happened?
Many things. Number one, that it happened. Number two, there was a tax error. Number three, that she found it. Number four, that she confronted him. Number five, that she got pushed, which they still won't even admit, even though we have a transcript of her complaining about it. All these things, that she was treated disparately, she was treated differently.
The tax document was important to add credibility that this meeting took place where she was pushed.
Among other things, yes.
Okay.
I mean, it was a key. They won't even admit that. So that was a document that was important. I don't think that the case would have rose or fallen on the document, and it was an innocuous document. I want to just stress that as I sit down here, this was not the schematics for the DTE. This was not private legal memorandums. This was a document that they submitted to the federal government anyways, which would have been discoverable pursuant to a subpoena or otherwise, and it was sitting on her desk. So for those.
So we know your client testified to where she got it. Mr. Watson basically conceded he can't point to anywhere in the record rebutting her testimony, but can you tell us anywhere else in the record that corroborates her testimony, if there is anything, as to where she got it?
I know she got it from her desk. She's told me that. I don't know where in the record that is. If it's in the record, where it is. I don't know if that was fleshed out below. I just don't know. Because remember, this also occurred prior to my, I didn't get the document. Ms. Jennings did. So, and unless you want to hear from her, which I'm sure you don't, then I can't answer that question at this time. But this wasn't a super secret, document. So they want to make it like that. Our position is it's not. A jury should decide if it was and to what extent, using the Niswander or the Quinlan test, which I urge this court to adopt. And thank you very much, unless there's any other questions.
Anything else?
Nothing else. Thank you.
Thank you, Your Honor.
Thank you. Well argued.
Thank you, Judge.
Yeah.
Thank you.
Yeah.
You're going to cause us to take another break, though.
Yeah, very well done on both sides.
Have a good afternoon. Well, most of you have been here all day long. It's I was just, you're moving up, yeah, and you're moving up from the back, so it's I was just telling Judge Trebilcock, this is one of the longest days I've been on. I mean, this was a limited number of cases for this case call, but calling
Not
them.
my fault, for the record. I don't think it's my
Well,
fault.
I've only known you a little bit, but you can. Calling number 6 on our docket today, case number 367782 Dearborn Hills Civic Association Incorporated versus Fawaz Bitar. And it's consolidated with case number 367857 Dearborn Hills Civic Association Incorporated versus Fawaz Bitar. And then we have Tony Franzi, who is, I believe, representing the appellee, who's remote. Are you there, Ms. Franzi, and can you hear me?
I am, Your Honor. Thank you very much for allowing me to appear this way.
Okay, thank you. Counsel?
Good afternoon. Margot Cleveland for the plaintiff appellant, Dearborn Hills Civic Association, along with co-counsel Tim Doman. I would like to reserve 5 minutes for rebuttal. May it please the court. At first blush, this appeal may seem insignificant, but the lower court's multiple legal errors hold profound practical and legal significance. Practically, the defendants still own a home in Dearborn Hills. They still claim that the Dearborn Hills Civic Association lacks standing, and they have substantial exterior repairs that they need to do. It's therefore very important for us to have a ruling in this case so that the defendants don't return to their old ways, as the court put it.
When's the more of a just practical question.
Sure.
This case has been pending for a while.
Yes, it has.
Prior to today, have the parties attempted to sit down and work? What's still there?
Right. So we attempted below, but the plaintiff as an association has over 1,260 homes to take care of. And in order to make sure everyone is treated fairly and equally, our position has been we will either have a decision on the merits or a settlement agreement where there is an acknowledgement the deed restrictions are valid. There was a violation of the deed restrictions. We tried to do that early on. We tried to do it for more than a year, and then the defendants removed the cedar siding. So at this point, after having briefed 3 times below the issue of standing, twice at this level when defense counsel sought an interlocutory appeal, and once before the Michigan Supreme Court, the issue of standing, we would like the court to reach the merits and establish in a precedential decision these important issues. So with that, let me start with standing. We, as I noted, would like the court to hold that the association has standing to enforce the deed restrictions. Our position is clear that Hammond Lake in 2006, that this court already addressed the issue and that it's controlling. In that case, the court held a voluntary association whose sole purpose is to represent the interests of its members may bring suit to effectuate that purpose, regardless of whether the association itself owns any land.
Why is their reading and impact of Bloomfield Estates wrong?
So Bloomfield Estates had nothing to do with standing. All it said is that you give the deed restrictions its plain and ordinary meaning. The plain and ordinary meaning of the deed restrictions is it says homeowners can enforce the deed restrictions. It does not say that the association cannot. After Bloomfield Hills, this court in a case called Smiley again applied the Hammond Lake decision. Hammond Lake was actually based on well-established principles of standing with a third-party association. Smiley also rejected the idea that Hammond Lake was unique because it was riparian rights. It was basically just general principles of standing. And on this point, I'd like to make clear that below, we actually argued multiple bases of standing. I like to do a kind of belt and suspenders approach to litigation. But we are not arguing standing based on assignment. I'm expressly waiving that. We want the court to make clear that Hammond Lake remains good law and that the association has standing. Does the court have any other questions on standing?
Nope, why don't you go on to your deed restriction claims?
Sure. So on the deed restrictions, the second important error that requires correction is where the lower court on page 3 of his brief, which is on page 10 of our appendix, stated that we did not file the original, we did not file the reaffirmed deed restrictions, that we had only filed partial deed restrictions. That actually is not accurate. Attached to the complaint, which is exhibit 25A, and it starts at page 345 in our appendix, are the entire deed restrictions. And if you refer to Article 1, it talks about how the undersigned are acknowledging that they can prepare these in several batches, and that nonetheless, the restrictions so prepared and executed are deemed to be one and the same. We prepared and filed in the attachment the entirety of the deed restrictions. What we did not file and were not required to file were the signatures from the 1920s, from the 1950s and 60s, and then in the 1999s when it was renewed. That would have added thousands of pages to the record just of the signatures. The entirety of the deed restrictions, which is a contract, was filed with the court. And in Totus versus Dearborn Hills, the Michigan Supreme Court affirmed that our deed restrictions were not waived. That case was a class action lawsuit, so it established binding precedent, binding based on both res judicata and collateral estoppel. I quote in the brief how at that time that case came, I believe in 2000, they had a jury trial. That was shortly after they were renewed in 1999. So the deed restrictions were properly filed. They weren't waived. They're binding and enforceable. We had 3 claims under the deed restrictions that we brought. It's important for the court to recognize that this was decided at the summary disposition stage. This was not after a bench trial. So the questions are questions of law. And in the case of Dearborn Hills Civic Association versus Mary, this court made clear that if it's merely the application of undisputed facts to the deed restrictions, and that case was the deed restrictions in this case, it is a question of law. The first breach was Article 2 of the deed restrictions. Again, that is in Appendix 25A, Article 2.
That's a pre-clearance requirement?
That's the pre-clearance. So Mary said that there are 3 requirements. First, you have to present plans to the association. Second, those plans have to be in harmony and conformity. And third, you have to have written approval for the plans. In this case, it's undisputed that the defendants put cedar siding over their Tudor house. On page 2 of the appellate brief, I have pictures of that. That remained up there for more than a year. It's also undisputed that they never submitted plans prior to installing the cedar siding, and that the association rejected them because they were not in harmony and
What
conformity.
year was that house built?
It was probably built in the 1940s. Most of the homes in our neighborhood were built between 1920 and maybe 1960.
Yeah, I was looking at the house next to it. Certainly looks like it's more modern in the 60s or 70s.
Right, that was more of a 1950s or 60s. So what happened is they went through 2 waves. Basically, we had the Depression after it first started. Then there was kind of a post-World War II boom, and then some more in the 50s. So we'll have.
And the house at issue looks like it's a little bit more recent than the house next door. But anyway.
You know, I would have to look at.
Something the Appalachian Council can answer.
Right, I'm not sure what the date of it is, but whether.
A lot of housing in that area. I don't know about Dearborn Hills. They're knocking houses down and rebuilding.
Exactly. And we are having some of that in our association, but most of it is not, because most of the new rebuilds are modern houses and they aren't controlled by deed restrictions, which again is why this case is important to get these principles established and make sure that we don't have to keep relitigating the exact same issue over and over again. So if you're going to argue, we need to get a resolution to it. So what the judge said in this case was, this isn't an alteration. And frankly, as a matter of looking at the plain understanding of what an alteration is, that is an error of a matter of law. I would argue it's actually clear error, but again, that's not the standard. The standard is quite plainly, if it's
It's only the front portion of the house. It's not like they sided their entire house with some other.
right. And this is exactly what people see when they drive by. So it was an alteration when they did it, because an alteration is changing as defined, and the court defined it, changing in its character or its composition. The composition is plaster. Now it's cedar. The character is a Tudor home. Now
It's a home.
it's a home.
But isn't the violation of the deed restriction even more plain than that? I mean, in Article 6, it says all exteriors must be made of, quote, stone, brick, or stucco.
Right. It also does allow for wood to be attached for some wood siding if it's approved.
Right.
It's like a double. You got to approve it. Plus, you really got to approve it if it's wood.
Right,
S-
exactly. So if
so-
you're altering, you got to get approval. And then if it's wood, if you're doing any wood siding, it definitely needs. approval.
Right, exactly. So this was clearly an alteration. Again, it's a question of law for you. You see the pictures. It was the front of the house. It wasn't the whole house, but actually the front of the house makes it worse because it is taking away from the view. This, the beauty of the neighborhood, which they are historic homes, but if you think about it, we're getting old. The 1950s is pretty soon going to be over a century.
So why isn't this moot if they've, as you acknowledged during the pendency of this litigation, taken
Absolutely.
cedar off?
So 2 reasons. The first and the simplest is we're entitled to nominal damages. It's clear in this court that you get nominal damages for a breach of contract. And I can reference Duckett was the case where they actually talked about that, where you could have a breach for a breach where you get nominal damages, and that does not moot the case. In addition, just
They still, even if it's 6 months, they still change the character for that 6 months.
right, exactly.
There's no time limit on the amount of time that you can put, be in nonconformity with the deed restriction.
Right, absolutely, which is actually one of our third claim, where if you're going to build, you're supposed to have it done within a reasonable time or no more than 4 months. What happened here is they stuck it up. We said, hey, you're breaking the deed restrictions. Let's try to work this out. There was initial cooperation. We have a designer who does a lot in the neighborhood who is very good at kind of freshening things while staying historic. The homeowner met with her and then said, I'm not changing it. She never did plans. We said, where are the plans? She said, they're not going to change it. I made multiple outreaches to defense counsel to find out what was going on. It sat there for 4 months. And after 4 months passed is when we filed the lawsuit, and then it continued. So yes, there was harm. The nominal damages is the minimal. But the other part of it is the case law is clear that you can't, voluntary cessation doesn't case. And that's really important here because the outside of the house still needs repair. The plaster is in really bad shape. EFS is what a lot of cheap contractors use. It's the kind of spray-on stuff that they use at like home, not homes, businesses. That would be completely out of character in Dearborn Hills. If they're going to redo it, they need to come to us again. They were going to have to redo it. Defense counsel said they were getting quotes. It could be up to $50,000. So for those 2 reasons that the case is not moot, nominal damages, and you can't just voluntarily stop when you're about to lose to moot the case. I would like to touch briefly on the alteration not being in harmony and conformity. And again, this is important for our other cases. In this case, the judge said you didn't present any evidence of what harmony and conformity means. And again, as I pointed out in our petition for reconsideration, that absolutely was not true. We highlighted where we argue to the judge, this is not in harmony and conformity. And I referenced that in the briefing. We had 4 pages of arguments, but at a minimal, we have an affidavit that the court considered that was the association found it was not in harmony and conformity because this is not how Tudor homes are designed. It doesn't fit in the neighborhood. And we had pictures of all the other Tudor homes in the neighborhood. By itself, under Mary, which was this Court of Appeals decision last time I was up on the merits, under Mary, the court said that is a decision for the association. It's not for the court to decide unless there's evidence of bad faith or mistake, something along those lines. Defendants presented nothing to suggest that. So the evidence undisputedly showed that we prevailed. What the judge did do is he disregarded our expert's affidavit, which he said was not signed. It was signed. I presented that in both our brief and in the appendix. We don't actually even need that because we have enough other evidence of the harmony and conformity. I do want to talk briefly about the remedy. I said at a minimum, we have nominal damages. But we have another issue here that I want to focus on because it is an issue of first impression.
But we wouldn't decide the remedies up here anyway, would we?
Well, we are asking for the court to decide the interpretation of the deed restrictions. So if the court decides you're just going to send it back for the lower court to decide if the remedy we seek, that would be, I guess, within your prerogative to do. So let me then move on to the other claims that we have. We also have a breach of deed restriction claim. I'm sorry, plan review claim. The Civic Association is not an HOA. And that's important, I think, for 2 reasons. One is to understand why we're here, because we need to get the precedent. We're different than an HOA in that we don't have any mandatory dues. We don't have the ability to find a homeowner. We don't have the ability to assess. All the money we get is from voluntary donations or voluntary $25 membership. And because we're not an association, a homeowners association, what we do is we ask homeowners to enter into to fill out a plan review form in which they commit that they're going to abide by, they're not going to build contrary to what we approve. Because what we have found in the past is we approve something, they do it, and then they ignore it. And it puts us in a worse spot.
But doesn't it, don't all the obligations of the homeowner who submits the form, none of those spring up until there's approval, and there hasn't been an approval
No,
in this case.
you're absolutely right that
So
there
how can
has,
we have a breach of contract?
because they've repudiated it. So they still are going to be submitting plans when they've fixed the outside. So the condition for their duty hasn't arisen, but because they have repudiated the contract, that is a breach now. And that current breach allows us.
You didn't approve the plans. Don't they have to submit new plans to repair? Weren't you just talking about how they have to get the right kind of stucco on and not the cheap stuff? And so
Right.
they have to resubmit? Wouldn't that
Right.
be,
Except,
that would be the basis of your claim, not the current pre-approval form that's in front of us?
except for they've already said that this is not a contract. They're repudiating this contract.
But is
But
there
it's-
something in the deed restriction that gives you the power to force these homeowners to enter into a contract with you?
Absolutely not. And we're not forcing them. We've had other homeowners who refuse to. And in that case, we review their plans, we give them a decision. What we don't do is have somebody who is a licensed builder go to the site, spend hours talking with them, trying to help them come up with plans. That's for them to pay their contractor to do. So we do not force anyone to enter them. We've had people refuse to sign it. But if they do that, then we will only review complete plans, not sometimes people come and say, well, we're not sure what we want to do on the outside yet. We will approve on the condition that they come forward and give us the specifications, and then we approve it. But we couldn't approve it without the specifications otherwise. So absolutely agree with your concern there. The final claim is the fraud claim. And on this case, and on the fraud claim, our lawsuit here is alleging fraud under the Highway Motors case, where someone enters into a contract never intending to perform.
Would you agree if we don't find there's a contract, then there's no fraud?
I would, absolutely. If you would say that there's no contract, but again, I would say, at least from our questions, you said there is a contract, their duty just hasn't arisen yet. That they, until we approve it, they don't
Well, you
have
already
to.
rejected the one contract. If you assume that the pre-approved, on the architectural plan review request form, they submitted that after they put the cedar up,
Yes,
you rejected that.
we did, but if they,
Okay.
if,
So that's all that's before us at this point.
correct, but
So
you're-
isn't that, then that's done? There is no contract because there's no mutuality. They made an offer. These are our plans. You guys rejected it. There's no contract,
so what
no
they,
mutuality.
right, so what they asked for, and when they did the plan review, was they presented plans, and it wasn't specific to one set of plans, it was to redoing the siding, redoing the outside of the house. So as long as they're still within the terms of what the plan review, they asked for review of, redoing the outside of the house, then the contract still exists. If they come back and say, okay, we don't want it Tudor, we want to make it a colonial style house, they actually could do that. They could bring us plans that have siding and it's painted, and we could approve that. But I would absolutely agree, if there's no contract, then our fraud claim would not prevail. The final point before I will reserve the rest for rebuttal is the counterclaim that I'm sorry, not the counterclaim, the request for sanctions. After we filed this lawsuit and it went back and forth numerous times with motions to dismiss, they eventually answered and they filed 3 frivolous counterclaims for conversion, for fraud, and for abuse of process. The lower court did not make a factual finding that there was no frivolous claim. He just denied damages. In this case, I'll just focus on conversion as the example. They alleged a claim for conversion. At no time did they allege that we took possession of the cedar siding. We never took possession of the cedar siding. The lower court dismissed each counterclaim within a sentence or two because it was well-established law. There has to be a ramification when an attorney presents frivolous claims. So I would ask the court to remand that for the court to decide what the reasonable attorney's fees are. And before reserving the time for rebuttal, defense counsel made several accusations that were both against the association and myself that were false. I don't have anything to say about those unless there is something that raised the court's concern. I would like to have a chance to make sure to address it. Okay, I would like to reserve the rest.
Thank you. Go ahead, Ms. Francis.
Thank you, Your Honor. Tony Francis, appearing here for Ms. Bitar and for Mr. Huady. We believe that a fair reading of this case requires a conclusion that the appeal and the case before it are unfound and that the lower court's decision should be affirmed. This case is one of 22 now cases that Ms. Cleveland has filed on behalf of the DHCA.
22 against you?
No, 22 cases.
Let's talk about yours.
Okay. We think that what's important here is that while the DHCA lawsuit was pending, the board changed the bylaws to prevent anyone who lost, even on nominal damages, even on an arbitrary yes or no, you lose, from ever becoming a member or a voting member or a member of the board.
Isn't that's a separate issue from the subject of
Sure.
litigation, right? I mean, the issue is here is do you agree there's deed restrictions, right?
There are deed restrictions.
And
Yes.
those deed restrictions require your client to go to the association to get approval for anything that constitutes an alteration to the exterior.
I'd
And,
like to, oh, I'm sorry, Your Honor.
and the deed restrictions say that the exterior has to be stucco, brick, or I'm blanking on the third one. And if you're gonna use wood, you got to get pre-approval for that. Are we agree with all of that in basic at its top line, right?
Well, top line perhaps, Your Honor, but I can turn directly to addressing each of those restrictions in turn. But before we do that, I'd like to first state with regard to standing that counsel's argument appears to be that we want a decision from this court, and I agree with that. I think a decision on standing is important here. What I am arguing here is that Hammond Lakes is an appellate court decision and Bloomfield is a Supreme Court decision. That's one argument. But the more important argument is counsel arguing that they can have standing either because of what the deed restriction Article 12 says, or on the basis of Hammond Lakes? Because if that's the argument, I strongly disagree. Because if we're going to say that Article 2 has to be enforced as written, which I don't think there's any dispute, everybody agrees it needs to be enforced as written, then I think that we also have to enforce Article 12, sorry, I was going to say 10, 12 as written, and I'll get to that in just a moment. So for that reason, I would say absolutely not. If Hammond Lakes is not applicable, if there is a deed restriction that does state who and how a lawsuit may be brought, because that's the covenant that runs with the land. The covenant that runs with the land is Article 12. That's the notice. And no way should there be any decision by a court in a different case that would take priority over what the deed restriction says, unless that deed restriction is somehow unenforceable, which, I mean, there could be public policy reasons or other reasons why it would be, but I don't think that argument's being made here. So I think if the argument is that we can have standing because of Hammond Lakes, or we can have standing because of Article 10, forgive me.
Let me ask, Article 12 says, it's the deed restriction governing the disposition of the case before us. And it says, gives a cause of action to any other person or persons owning any real property within the subdivision for deed restriction violations by others. Why would this not give standing to the appellant?
The appellant is a voluntary association.
Yeah, but they're homeowners.
And could you have that in organizational standing?
We addressed that as well. Not if what the grantor intended, and there's a couple of reasons. Not only because that's what the grantor said, but also because if you parse Article 12 as they're requesting that Article 2 be parsed, you cannot read out the difference between the first phrase and the second phrase. In the first phrase, it says the parties hereto, which are the homeowners, not the association. The homeowners, or any of them, or their heirs, or assigns, shall violate or attempt to violate. It can be unlawful, blah, 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 blah. That's the first phrase. But then the second phrase leaves out heirs and assigns. That second clause says you can be the prosecutee, you can be the person prosecuted for, but you cannot be the prosecutor. So if you are going to interpret an unambiguous clause as written, which nobody disputes here, that's what Bloomfield says, that's what opposing counsel is saying with respect to Article 2, everybody's saying the same thing. You got to read the whole clause. You got to read the whole article. And that article says something very different in the first clause. It includes heirs and assigns than it does in the second clause where it's left out. I would argue, Your Honors, that that's because the grantor intended that. In fact, I think there's plenty of law that says that's how we have to interpret that phrase. So
Why don't we get under the deed restriction?
so turning then to the kind of the second serious argument that's made is that there's been an alteration. Well, DHCA wants the court to read Article 2 in a hyper strict construction, but wants the opposite with respect to Article 12.
Okay,
So-
we'll deal with that. Let's
Okay.
argue the deed restriction claims.
I am. Thank you, Your Honor. The DHCA focuses on the word altered in Article 2. Using a dictionary definition, as the trial court did, would seem to be as generous to the DHCA as possible. And construing the restriction as written does not mean that you don't construe it at all. And we believe that a fair and proper construction as written must consider the drafter's selection of the words erected and placed within that same serial list, which seems to denote a requirement of permanency. Otherwise, what if decorations for a graduation party or an at-home wedding were to include affixing wood ornaments or strings of party lights to the faces or the eaves of an existing home? Would that require pre-approval? How about Christmas lights? My dad one year made toy trains out of plywood and put them on the face of the house. Would that have required pre-approval? It seems that if you're going to read altered to mean any alteration in the simplest definition, then anyone could be found to have altered. But
So you arguing selective prosecution by the homeowners association?
no,
All right, that seems to be what you're saying. That
no,
they should file suit against everybody, not just your client.
well, I kind of think they are, but that's beside the point, and Your Honors have let me know we should move aside from that. I won't argue that. I'll leave it to what's in my brief. No, I'm not saying that at all. What I'm saying is that there's a list of 3 things in Article 2. Those 3 things are erected, placed, and altered. And I think that if you're going to take erected and placed together, and you're going to say, okay, that's somebody adding a wing, that's somebody attaching a garage, that is somebody putting a permanent sunroom on the back of the house. Yeah, that's an erected change. That is a placed change. But if you're now going to say, oh, but in the third word meaning altered, that just means anything. That means anything at all. It's a catch-all. Is that what it means? I don't think that's what the drafters intended. I think the drafters were intending to use those 3 words together and was thinking of something more permanent than what we had here. And I think ultimately that's what the lower court decided. And the case precedent is clear that these cases are decided on a case-by-case basis, and that the lower court's decision is entitled to deference, a very high level of deference, and can be only overturned.
We have a de novo standard of review here.
I'm sorry, Your Honor.
Do we have a de novo standard of review here?
For summary disposition, yes.
So counsel, how do you how do you avoid the language in Article 6, character and value of the buildings, that says all buildings shall be constructed of stone, brick, or stucco exterior. A wooden exterior may be used providing same has been approved and detailed in writing, et cetera, et cetera.
Right, I don't,
Doesn't that inform, if we're reading these restrictions in total, inform what an alteration or modification is? And it specifically says you can use wood on the exterior, but you got to get pre-approval.
I don't disagree with that, Your Honor. I would, however, say that that question, I believe, goes more to the question of whether or not we have an existing contract than it does the deed restriction, because there's no dispute that this was wood instead of stucco or what it was that was put on. That specific question, I think, goes more to whether or not there was an existing contract for my client to have breached. I mean, we can't.
How does that not go to whether or not there's a violation of a deed restriction? It says in the deed restrictions, Article 6, pretty plainly, all buildings shall, meaning mandatory, be that, and you can use wood exterior, but you have to get approval. And if you don't get approval, if I'm reading into that, that violates Article 6. Why can't I just read that plainly?
I think you can. I don't think there's any reason why you can't read that plainly as well. But I don't believe that with respect to that question, my client never had an intention of breaching any deed restriction. That was clear. There's no dispute about that. There's no record evidence. In fact, there's record evidence there was clearly not an intention to. And that is
evidence that there was a violation because cedar exterior was put up prior to approval. Isn't that evidence in itself of a deed restriction or a violation of a deed restriction?
It could be, Your Honor. I do not believe that is controlling in this case. With respect to the mootness argument, I rely on not only what we argued in the court below, there was not a scintilla of evidence that my clients intended to do so in the future. And there's no dispute that if my clients wish to make or are required to make changes to their home, that going forward, another request for approval would be required if there are any changes that are being made to the exterior of the home. I would like to note, and I was pronouncing it wrong, I guess it's Totus. I'll rely on Sister Counsel's pronunciation of that last name. Again, was a class action lawsuit, and so cannot go to the merits and cannot have any res judicata impact on any subsequent cases. I think that was briefed properly. Unless there are any other questions, I don't believe I have any more, but to focus on the reasons why standing should be denied here. And just to add on to what I said at the beginning, is that I don't think you can read Article 12 in the same way that you're reading Article 2 or even, as Your Honor indicated, the other article, without also applying that same principle to how you read Article 12. And if you apply those same principles of expressio unius est exclusio alterius, or expressum facit cessare tacitum, only because I took Latin for 4 years in in high school. I need to make those part of the record, that the fact that that language is in Article 12 in the first clause and not in the second clause should be given meaning and cannot be excluded.
Questions? Thank you very much, Ms.
Thank you.
Frenzy.
Thank you, Your Honors.
Have a good day. Well, you're going to stick around for rebuttal, I would imagine.
Yes, please, Your Honor.
Go ahead, you have a few minutes.
Thank you. Just a few points. As far as standing, the general rule is that a contract is assignable unless the contract prohibits assignment. Article 12 does not bar assignment. It has nothing to do with whether or not the association has third-party standing. Hammond Lakes is controlling. Hammond Lakes deed restrictions had the exact same type of language as are here, where it named homeowners as being able to provide and bring a lawsuit, but was silent on whether or not the civic association could. Hammond Lake is controlling. We are not relying on Article 12, but common law principles. As far as whether or not there was an alteration, the court is to give its ordinary and generally understood meaning of that. Obviously, hanging Christmas lights is not altering a building. It is, as the court below said, by looking at the definition, a change or a cause to change in character or composition, typically in a comparatively small or insignificant manner. Changing from plaster to wood, changing from a Tudor to a different style is an example of what a change is that would be considered an alteration. And that's not just important for our case, which as defense counsel noted, I've brought 22 of those cases on behalf of the association pro bono. So I'm looking to pass the torch quickly on that. But that's why we need a ruling, because we need to have.
There are 150 homes in the Dearborn Hills?
No, there's 1,260, over 1,000 homes.
And it's on the east side and the west side of Telegraph.
It is.
Okay.
Originally, Telegraph wasn't going to go through it. We're actually the oldest homeowners association. We just celebrated 100 years.
I know you got the golf course there on the
We
west
do.
side, and you go to the east side. It's a beautiful neighborhood.
It
Mount
is.
Kelly's down there.
Yeah, it's a gorgeous neighborhood. And just outside of our border, the houses are being torn down. You're getting
Dearborn Heights is really.
McMansions, which were this old house neighborhood. That's why we live there. That's what we love about the neighborhood. And that's why I've spent all this time on 22 cases volunteering to get the deed restrictions enforced. As far as permanence, in this case, it was intended to be permanent. In fact, the judge said there was no conversion case because you can't convert real property. The cedar doesn't become real property unless it's attached permanently. Defense counsel said that they were getting quotes and expected to be up to $50,000 from the cost of the damage caused by removing it. There was clearly an intent for it to be permanent. And in fact, if you look at Article 13 or 12, I'm sorry, it says if the parties violate or attempt to violate the deed restrictions. So even if they argue it wasn't permanent and therefore it's not an alteration, they were trying to violate the deed restrictions. They argue that there was no intent. The actual evidence shows different. It shows when they first applied, it said, we're seeking permission because it says you have to get permission to apply wood. They already applied wood.
Would that wood be considered a fixture once it's stuck to the house? You know, it turns into real property.
It turns into real property.
So that would be a fixture then, correct?
Correct. Yeah. So, which is why the court says you can't convert it. We thought they meant the cedar they never used, which they couldn't convert either because we never touched it. So either way, it was a completely frivolous claim. The intent to breach, obviously, though, is not a requirement for a breach of contract. So the fact that they breached it by itself gives us a right to recovery. And as I noted, we have a right to nominal damages. the Duckett versus Soki case made that clear. And actually in February in Powers versus Bone, this court recently remanded a case involving deed restrictions where they were seeking only nominal damages as well. Finally, on the case of Totus, the fact that it is a class action lawsuit makes its findings factually controlling for every homeowner under collateral estoppel, and its legal findings and anything that could have been raised controlling under res judicata. I mentioned this and discuss it in the briefs, but the fact that it was a class action is actually why the court does not need to delve into those issues. As a successor in interest of this property, they are bound by those decisions. If the court has no further questions,
Thank you very much.
thank you,
very
Your
much.
Honor.
Thank you. Have a good day, Ms. Francis. Safe travels out to Dearborn. All right.
Oh.
Case is submitted.
Thank you.
Perfect. Thank you.
Calling the seventh and final case on our docket for today. Case number 369-872, DBK and DEK Limited Partnership LP versus Alan Catkin. Counsel, identify yourself, please.
May it please the court, I'm Cindy Rhodes Victor on behalf of appellants.
Thank you for being so patient today. Go ahead.
No problem, Your Honor. And I will try to keep it less long than the preceding arguments. I know that I've been in front of this, those of you on this panel before, and I know that you read the briefs and that you are on top of it. Happy to answer any questions. So I will just hit the highlights, and if you have questions, let me know. I'd like to reserve 5 minutes for a rebuttal.
Okay, go ahead.
Thanks. There's really 3 parts to this appeal. The first part is the determination that Alan Catkin lacked the right to assert an interest in the subject property. The circuit court ruled that Catkin was not a real party in interest and didn't have a lawful cause to file a claim of interest. But this is contrary to other decisions of this Court of Appeals. We do cite an unpublished opinion, Dice versus Zimmerman, but it had very similar facts. And while unpublished opinions are not controlling, and I appreciate that, it certainly does give us some guidelines because it does cite to published cases within it. In that case, the parties had claimed that the trust beneficiaries did lack standing, that they were not real parties in interest. And in Dice versus Zimmerman, they found that that was not the case. Trust beneficiaries are interested people, and they have the right to invoke at least probate court jurisdiction. And so while a trust beneficiary may not, they cite to Apollinari versus Johnson, 104 Mishap 673, a 1981 case. While a trust beneficiary generally may not maintain an action against third parties if a trustee is entitled to do so, a beneficiary can sue in equity if a trustee refuses or neglects to do so. In this case, the evidence was unrebutted that the successor trustee, Robert Catkin, failed to challenge the transfer of the property from the trust to DBK and DK without any consideration. And so in fact, he was later removed by the probate court for his actions, which was introduced into evidence. Since the successor trustee failed to protect a trust interest, Alan Catkin, as a trust beneficiary, filed the claim of interest. And it said, I'm filing it as a trust beneficiary. Didn't hold himself out to be the trustee, didn't hold himself out to be anything else. So then the issue came of statute of limitations. And the court found that the statute of limitations ran out 15 years after the deed was recorded. But in 2002, when the deed was recorded, Alan Catkin, I keep using first names because there's a lot of Catkins in this case. Alan did not have a right as a trust beneficiary. He only had a contingent interest. Doris was still alive until September of 2007. And then during that period of time between 2002 and 2007, she could have revoked her trust. She could have cut Alan out of the will, out of the trust. She could have done any number of things. So he only had a contingent interest. He didn't have an interest as a trust beneficiary until she died and the trust became irrevocable. That happened in 2007.
And when
As
was
to-
this case filed? 2017?
This case was filed in 2017,
Right.
correct? Well, I think this case was filed in 2018.
Okay, I knew it was one of those years.
Right,
you-
but 2017 was when the claim of interest was filed, November 1st, November 2017. And yeah, November 1st, 2017, I've got it here in my notes. The trust owned the property, but the April 25th, 2022 deed was not from the trust to DBK and DEK. It said that it was from Doris personally and was being transferred via power of attorney. We, in our brief at page 19, have a whole line of cases I'm not going to repeat now because it's 3 o'clock in the afternoon about that a conveyance by a party who has no interest conveys nothing. Doris, a deed from Doris to anybody for that property could not convey an interest in the property because Doris didn't own it. The trust owned it. And there was no deed in 2002 transferring it from the trust to the DBK and DEK. And so as the cases that we cite say, and I rely mainly on Richards versus DePaldi, 272 Mishap 522, 2006, it is clear beyond dispute that a grantee from a party conveying by quitclaim deed acquires the right and title which his grantor had and no other. Here, there's no dispute that the KDCs in the party had title to the property, did not have title to the property.
Wait,
When it
wait,
was-
but Richards, the action in Richards was filed like 2 years after the transfer.
Correct.
So well within the statute of limitations. Every single case that you've cited was a case in which the plaintiff filed their action sometime prior to the 15-year period so that they were able to timely challenge the transfer.
Right.
You have not cited one case that I have been able to find where the action was filed after the 15-year period. Is that fair to say?
That is fair to say. I don't see a case that says that, but we look at the statute of limitations, statutes. And under 600-5801, it's more specific than the general rule on which the circuit court relied, which is that a claimant cannot make a claim for recovery or possession of land until it first accrued to himself. So the claim for Alan did not arise until Doris died on September 29th, 2007. Because that's when the claim accrued to him. He wasn't a trust beneficiary of an existing, he was only a contingent trust beneficiary until she died on September 29, 2007. And when you look at, it's another published case that we cited, Reese versus Lyon Township. In that case, this court said that the property held in a trust doesn't transfer to contingent trust beneficiaries until the death of the present holders. So while I don't have a case, Your Honor, that says, 18 years later, I'm bringing a case to challenge this, because there is no case like that I've seen, it would make this a case of first impression. We have the more specific statute. Then we have some guidance from Reese versus Lyon Township on when Alan's claim accrued. Turning to the second part of this.
Well, let's go back to that for a second. So your client's claim arises out of a trust, right? He's a trust beneficiary. So I'm looking at the statute you just cited. It says, first accrued to himself, as you said, or to someone through whom he claims. Isn't the someone through whom he claims the trust?
But it could be either that or through someone he claims, but at that point, he didn't have a right to be the beneficiary. So that's the difficult part. That's where we have to look to Reese versus Lyon Township.
Well, can we admit that if the trust would have had a cause of action for quiet title, it accrued in April of 2002 when the quitclaim deed was recorded, right?
Correct.
Well, so then if he's claiming through the trust, how is that not a 15-year statute of limitations starting in April of 2002?
Because he couldn't claim in 2002. He could not come into court in 2002 or 2003, or 2004, or 2005, or 2006, or even 2007 through September of 2007 and say, I'm challenging this action, because he only had a contingent.
But he had 10 years, under your theory, he had 10 years within the statute of limitations that had started to accrue against the trust through whom he's attempting to take. He had 10 years to bring a quiet title action, and he didn't.
I understand that, Your Honor. As we refer in other places in the brief, he was given advice by his then attorney, Miroslav Volko.
He had 9 attorneys, didn't he?
He did not actually have 9 attorneys. That's a great thing to say, but he.
Well, no,
did
I'm
not.
not, I don't think it's a great thing to say. It's something in the record that he had 9 attorneys.
Yes, but it actually isn't. His mom.
Okay, and
would
then
hire-
he has reading issues as well, correct?
Does.
Comprehension.
He does.
What-
absolutely. His
so
mom
it's
would
not-
hire a number of attorneys because they weren't getting their answers on various things. But Mr. Volchko began representing him in 2015. And he is the one who told him that the statute of limitations did not start to run until 2000.
So you're asserting a reliance on counsel defense.
Correct. Yes, Your Honor.
So you're saying, in reliance on counsel, my understanding, I know of it through the securities context, securities regs, is that I have no understanding of the law. So I am totally reliant on you. I am not making these decisions. So is that what you're claiming about your client? He had no understanding of what a statute of limitations was. He had no understanding of the trust, the deed, any of that stuff. So I'm relying totally on my counsel.
Yes, a lot was made of the fact that he didn't read his own mail. And he and Pam McCoy testified that he didn't have the capacity to do so, that he had to have it read and explained to him. And that during the years first his mother did it, and then his ex-wife, his wife at that time, and now his partner.
So if the number of attorneys that he had was not 9, what is the number?
The number of attorneys that he himself hired were 2. And he testified about that.
Is that also true for attorneys that represented him? And anything involving his grandparents' estate? Only 2 lawyers ever represented him, right?
Involving his grandparents' estate?
Yeah,
I
that's,
think there was only one attorney, and that was Mr. Volchko. The other attorneys involved his father's estate. And they were in Florida, that it was not his grandparents' trust or his grandmother's trust. I believe it was Mr. Volchko. There may have been an attorney before who sent a letter, one attorney, but the primary person was Mr. Volchko. And then at some point I took over. Mr. Volchko isn't practicing anymore. But I took over at some point in this case.
Are you with his old firm, Mr. Volchko's old?
Mr. Volchko and I, at one point, were partners together in a firm called Strobel and Sharp back in 2001 through 2004. And then we met up again at Cuss Ryan. He was there in 2013. I started there in 2014.
Wasn't he with the Fossey Law Firm at one time?
I don't know. I don't know. He left Cuss Ryan in 2015. I stayed with Cuss Ryan until we dissolved in 2023. My partners wanted to retire. I didn't. Um, so I got the people and they got the retirement. They probably have a better life than me. But so that's where I've interacted with Mr. Volchko. That's how I know how to pronounce his last name.
I was calling him Vlico.
Yeah, Vlico is what a lot of people say. But it's Volchko. His father was a, I think Hungarian or Serbian war hero.
I have a much easier name or time with Irish names, but go ahead.
Yeah, I love my two last names. Rhodes and Victor are probably as easy as you can get. So the other attorneys involved were things that his mother hired and they represent. There were 2 lawsuits total, and now we're segueing into malice. There was one filed in 2003 that was filed by an attorney and naming Alan and I believe his sister Bonnie as the plaintiffs. And that 2003 lawsuit.
Oh, this was all in your brief, this history, correct?
Correct.
All right, let's get to the point then.
Okay, so that's, I'm sorry, it's just that you had brought up the 9
Okay.
attorneys, so it
All right.
involves different.
So everyone had attorneys.
Yeah.
All right.
No, so Mr. Volchko was hired in 2015. He began researching it, and you asked about the advice of counsel. So it ties in with the issue of malice. Did he act with malice? And the critical element of malice is that he has to knowingly file an invalid lien with the intent to cause the plaintiff injury. Alan Katkin did not know the claim of interest would be determined to be invalid. He testified, and it was not rebutted. He testified that he hired an attorney because he doesn't understand law. He has a high school education. He works as a landscaper. He has a company that cuts lawns. He hired an attorney to tell him what to do. Mr. Volchko testified at length that in 2015 he was retained. He went through the records. He hired Seaver Title to do a title search. He looked at a number of different things. He communicated, I think we introduced 12 emails back and forth with DBK and DEK's attorney, saying, we need this information, what's going on. And then Mr. Volchko testified and Alan Katkin testified that Mr. Volchko said to him, you need to file a claim of appeal. And Mr. Volchko, the attorney, drafted the claim of appeal. Now, the question is, did he tell him to go and file it? No, he advised him to file a claim of appeal. And did Mr. Volchko file the claim? No, Alan filed it, but he got it from his lawyer. He didn't walk in. There's no testimony in the record that he walked into his lawyer and said, I want something that's going to, stop that. I want to do something. I want to hurt these people. All of the unrebutted testimony, because there was no testimony from the other side. All of the unrebutted testimony was that Alan Katkin said, what do I do about this property? And Miroslav Volchko spent 2 years researching it and said, and drafted for him a claim of interest. Then the testimony was that his partner Pam McCoy said, Mirko called and said, you have to sign this and file this claim of interest. She got the claim of interest from Miroslav Volchko. She met him at a bank. He signed it at a bank in front of a notary, and she took it and recorded it based on the direction that Mr. Volchko gave her. So when we say, well, he didn't say tell, or he didn't, the very fine lines. What do we do as lawyers? We advise people to do things. He is not in a position to think this is wrong or it hasn't, this man has researched this for 2 years. My lawyer must know what he's doing when he hands me a piece of paper and I sign it and record it, that he drafted, and he did draft it. It's right on there, drafted by Miroslav Volchko. So that's not a situation where he himself took an independent action. He thought he had a legitimate right to file this as the trust beneficiary because his lawyer told him that. His lawyer believed that. His lawyer believed that the statute of limitations had not expired. He testified to that on the stand, that he saw it as the death of Doris being the triggering event, and that he had 15 years from that date. Now, if we had a Wayback Machine, what could we do? Could we go back and say, if you had the case in 2015 and it's expired in April of 2017, maybe you should have done it before that date? Could be, but we have the facts the way we have them. And he relied on his lawyer for those facts. At no time prior to Mr. Volchko drafting the claim of interest and giving it to Alan, did Alan do anything? He didn't picket it. He didn't send nasty grams. He didn't, try to seize the property. He didn't file a lawsuit related to, he didn't do that. He didn't wait for his lawyer to tell him what to do. His lawyer said you need a claim of appeal to protect a claim of interest to protect your interest. He said, okay. Like I said, we're not talking about someone who's a CEO of a financial institution or an executive. We're talking about a man with a high school education who has difficulty reading. Coming down to the issues, did Mr. Volchko give him legally sound advice? Did he tell him that the claim of interest was valid when it wasn't? That's not material to a malice case. He had the right to rely on it, even if it was bad advice. He doesn't know from bad advice or good advice. And unfortunately, some of us practice one way and some of us practice a different way. The court determined that the lien was invalid, but it wasn't invalid because of any action that he took. He relied on his attorney. And if you've read the transcript, you'll see that Mr. Volchko was a little testy and arguing with the judge over whether or not the statute of limitations had run and whether or not it was valid. He believed while he was testifying that it was a valid claim of interest. Okay, I'm going to try to get to last interest. I had another argument this morning with the other panel, so I'm running out of breath a little bit.
I've been going a long time, the other panel. Go ahead.
Well, no, I was the first one there because I wanted to make sure I could get here. So I've been basically here since 10 a.m. going strong. Okay. The last one is that the circuit court erred on the attorney's fees and costs requested by the appellant. The statute is pretty clear that it's costs related to this action. The court, in a prior ruling, the circuit court said, quote, the probate action does not involve a claim of slander of title based on the claim of interest reported by Alan Katkin. Yet she allowed all the attorney's fees for the probate action to be recovered. In addition to the circuit court action, there was no distinguishing. If it was probate court action, she also allowed all of the legal fees that DBK and DK incurred before the cause of the claim of interest was even filed or the lawsuit was even filed. There's numerous time entries on the billing statements that are vague, and the testimony was that way as well. And often the witness didn't know what the billing entry referred to. There were duplicative tasks, same thing done by two lawyers that were allowed, despite case law to the contrary, which we detailed in detail in our brief. The court also allowed billing entries by clerical employees, which are not permitted under case law as attorney's fees. They're not recoverable costs. They're supposed to be part of our overhead. Several entries related to an appeal, which should have been stricken from the fee request that the witness on the stand on July 7th, 2023 said should be stricken, yet the circuit court awarded them. Costs from transcripts from the probate court action, again, having even the judge recognized that it had nothing to do with the claim of interest, the slander of title action, those were allowed. Allegedly, transcripts in this matter was allowed, even though the date was never disclosed and it was never used at trial. The transcript of the deposition of Pam McCoy was allowed, even though it was not used at trial. Charged as costs were such things as DBK's and DEK's annual incorporation fees that they pay to the state of Delaware.
Which was what, $105?
But
It was 102.
yeah,
Oh,
but
102, right.
it's still not a proper charge. And FedEx costs, copy costs, fax scan costs, postage, other FedEx costs. As to legal assistance, there was no testimony that the legal assistance met the criteria set forth in Article 1, Section 6 of the bylaws of the State Bar as required by MCR 2.626. And yet this was all permitted. There was no Smith versus Corey discussion. And the court's opinion says, as a huge error, says that they were charging, if you read the court's opinion, exhibit 104, that they were charging $250 an hour. And yet the billing statements show they were billing at $350 an hour. So we think the number was calculated wrong. And with that, if the court has any questions.
No, thank you.
Thanks.
Thank you. You have some rebuttal time.
Thank you. I'm gonna drink
yeah,
some
you
water
you have
here.
plenty of time.
Thank you so much.
Again, Scott Roddy on behalf of the appellee, PBK and PBK. Before I take a case or file a lawsuit, I will make a decision as to whether I want it to be a bench trial or a jury trial. When I was presented with this case after filed, I had the time to make that decision within that first 28 days. And I decided to have a bench trial. Why? Because I tried many cases with Judge McMillan, and I know her to be very meticulous in terms of paying attention in court. Very meticulous as it relates to the facts. Judge McMillan was meticulous in the facts and listening to the testimony and looking at the documents in this matter. The defendant has to demonstrate that there was a clearly erroneous determination of the facts and the evidence. There is nothing in their briefs, nothing in the record that demonstrates that there was any kind of clearly erroneous actions on the part of the judge in three separate portions. First, determining the statute of limitations and whether the claim of interest was valid. Secondly, in listening to all of the testimony regarding the issue of malice. And third, in the third part of the trial, which I requested bifurcation of the trial for that purpose, was the hearing on my fees and costs. Let's start in the fact. They did not award, the judge did not award all fees and costs requested. Fees and costs requested, well in excess of $300,000. We did not ask for, and nor was there an award for the two secretaries, paralegals that worked in this matter. No ifs, ands, or buts. It wasn't asked for. It was in our list of all our fees and costs because we give a list of all the fees and costs. So the exhibit that you've received, which was part of the record, was all of the fees and costs that were incurred throughout the course of that 2017 through the end of the trial, actually through just before the end of the trial. So that's a misrepresentation of the record. It's incorrect. The $103 or $102,000 when a corporation brings a lawsuit, limited partnership brings a lawsuit, if you're not licensed, you don't have standing to proceed. Every year we have to renew that. So we had to renew that. That's what, and so it was a charge because you're suing a limited partnership.
Your client would have had to pay it even if there had never been a lawsuit, right?
Yes, because they paid first Doris Kacken, and then they paid Alan Kacken and his sibling on a purchase agreement. There have been some statements here about things, arguments that were made at trial that did not take place. Defense counsel or appellate counsel makes two statements. First, that Alan brought the case on behalf of the trust. Well, they say that he brought it on behalf of the trust or filed the claim of interest on behalf of the trust. And then they say, well, he wasn't able to bring it on behalf of the trust. Which is it? All right, there's no testimony by either Vlecko, Letchko, or by Alan Kacken at any point during any of the proceedings that it was brought for any purpose other than to protect Alan Kacken's perceived rights against creditors to the property. That's what he testified to. So either he was bringing it on behalf of the trust, which counsel says he couldn't do because he was contingent beneficiary, which actually is incorrect, because the statute that I cited on beneficiaries, a contingent beneficiary can bring a claim if the trustee at the time does not want to bring a claim or that to show that. Guess what? At any time from 2002, when he was told and knew that this property was not in Doris Katkin Family Trust, at that point, he could have asked to be appointed trustee. He could have asked the trustee, any of the trustees along the line, will you file suit? He didn't. He never asked that until finally he figures out, he and his lawyers figure out, we better do something. So we're going to file a probate action to have Alan installed as the new trustee and to have a clawback of all of the deeds. When I submitted the exhibits in this case, submitted the petition filed by counsel, the order from the probate court, counsel specifically requested a clawback of all, and it uses the term all, deeds having to do with the trust. I had to take part in that in the outset and had to move for summary disposition of that claim because we had filed our claim for slander of title in the circuit court and Judge McMillan. What Judge O'Brien does, he says, I'm going to let Judge McMillan decide the claim of interest and the slander of title. I will handle whatever Robert Kacken did or didn't do. And by the way, I am not going to allow, no matter what, fallback of any of the property. So that's really what happened in the probate. Why did I take part in the probate proceedings after my client was dismissed? As Judge McMillan found, witnesses in that case are witnesses in my case. I sure as heck want to know what they're saying in another court. I want to be able to get their transcript and use it if necessary, as it relates to their credibility and their arguments.
Is part of the $269,720 that the court awarded for attorney's fees, is any part of that for hours that were incurred prior to the date on which the claim of interest was filed?
Yes, and the reason that was the judge specifically found that Mr. Vlecko was actually making demands that the property be turned over to my partner, Tom Neiman. He made numerous demands, was sending constantly emails and making phone calls and letters demanding that the property be turned over, that we sign deeds, things of that nature. That's why it was included as part.
What's your response to the argument that instead of $250 an hour, the math actually works out to $350 an hour?
No, that's correct. The judge actually found that typically I get $500 an hour. I testified, I took $250. This woman had spent thousands of dollars through 9 lawyers, multiple lawsuits, And
His lawyers, all 9 of them?
all of them were his lawyers. He testified, and it's in the record, that the reason these claims, for instance, the reason the claims for accounting were filed in Florida, there was a lawsuit for that, was to find out information about the Rochester property. This, Alan.
Well, if we,
Kagan-
so what's the number of hours that, I know the number, the dollar figure the court entered for attorney's fees, but what was the number of hours, if you know? And if you don't know, feel free to
don't.
say.
I'm happy to let the court know in a supplemental brief, but I don't know, as I said. I did, that's why I was only collecting $250 an hour. There are, I think, a couple charges of $350 an hour from my partner. That was it. It doesn't work out for $350 an hour. That's if you include all of the hours spent by everyone during doing work. I want to make some.
Now you use the term, excuse me, let me go back to Ron. You talk about 8 lawyers in quite a few spots in your brief, but you don't cite anywhere where you calculate the number or you list where all these lawyers came from. You just say 8 lawyers.
Goldenberg, the first one he went to in 2000.
Yeah, how do you know? Is it in the record someplace?
I have all the, I would, and this is important. Some of the records were destroyed by Mr. Blecko. He admitted under oath. That's what the argument was with the judge, with Judge McMillan. Under oath, he testified he had destroyed documents. And he also testified he didn't produce the documents involving Florida lawsuits because he's only licensed in Michigan and didn't think that even though he knew that there were Florida lawsuits, that he had a duty to turn those over to the other side or to the court.
Did the trial court determine how many lawyers that your
Yes, it's in the,
Release the number
it's
9.
9. She listed
Says
9.
9. Yeah.
So are there less than 9 law firms? Yes. Are there more than 3 law firms or 3 attorneys? Yes. Each lawsuit was filed in order for him to figure out, or he and his sister to figure out, how can we get the Rochester property? If you look at the time records in his lawsuit to try and get custody of his grandmother from Florida, and she didn't want to move to Florida, he moved twice to have her determined to be incapacitated. Okay, lack of mental capacity. She didn't want, she lived out in her own apartment. She didn't want to leave, and that was denied, but in the documentation from the people at it's Florida's version of the VA Department of Health and Safety. There was discussions about the Rochester property. So, and for Mr. Vletko had very little credibility with the court, as you can see, once he admitted to the destruction of the documents. And once he made the claim that in discovery, I don't have to produce documentation of other lawsuits in other states, even though I know about it and have seen it, just because I'm only licensed in Michigan. I practiced for 36 years in 17 states and never heard of such a thing. Okay, it doesn't matter. The other important thing is, and I'll leave it at this. You look at whether there was malice or not. Read Judge McMillan's opinion, her second opinion on the issue of malice, in which she goes over the testimony and the history of Alan Katkin's activities, and then how he was creating arguments throughout, different arguments, and changing his story throughout all of his testimony. She made, I've never in all these years seen a judge make such a glaring statement. You're looking to your lawyer to make to answer, which way to answer the question after you've already answered it one way another time. I mean, it tells you there's nothing, this guy did not like Marlon. Did not like the fact that, guess what, his gravy train. Okay, this guy is getting hundreds of thousands of dollars from his father. His father dies, guess what? Who covers the medical bills for the grandmother afterwards and sends a letter asking for the son to help? Marlene Cactus. Did Alan ever help with any of those medical bills afterwards? No. Did he mind cashing a check for $116,000? No. Guess he couldn't have read that check. How did he figure out? How did, you know what account to put it in? You see what I mean? There is, as to his lack of mental capacity, he testifies under oath that there is mail he reads. He doesn't read all this. Yeah, great. Okay, you didn't, I can see if you only had a college education. He went to college for one semester, decided it wasn't for him, and that was it. Okay. He's getting hundreds of thousands of dollars from his father. And then his father passes away, the grandma, period. Guess what? Also, the other thing that they note, and I think it's important, they did not include in their exhibit to their appellate brief and their reply the fact that Doris Catkin, the mother, she voluntarily resigned, and the trust lets her voluntarily resign. They spent all that time talking about her not having a lack of mental capacity, not being examined by doctors. She doesn't have to. Page 15, section 7 allows her to resign at any point. Any other questions?
Mr. Roney, I just want to go back to November 1st, 2017, the date that the defendant recorded his claim of interest, correct? Now, you may have mentioned this, I might have missed it. How are you entitled to attorney fees before that date?
Lower court determined because demands were being made to cloud title. The claim of interest is the file document, but Letco had been demanding a transfer of the property. Allegations were made, hey, we're going to cloud title. So those were all things that were done in order to protect as a client, BBK and DK, as well as Marlene Cactus. And guess what? They're paying for attorneys every time Letco sends one of his emails, sends one of his letters, and makes threats.
Can we get a little bit of clarity with regard to the clerical costs? Because I'm a little confused about that. So first of all, we know that the exhibit with the costs was not admitted, but that evidence came in through your own testimony at trial, right?
No, so the costs in the very first 4 years of litigation is included. The cost and the last 8 months or a year were not allowed because I hadn't supplemented the answers to the discovery.
But then you testified about all that evidence
I
and
did.
it came in through your testimony. So I think if I recall correctly, and I'm kind of looking at something here, it looks like you did testify about costs related to clerical workers, but it wasn't charged as an attorney fee. In other words,
Because
there had been an amount that had been incurred by your law firm for some clerical work, and that was, it appears to me that it was included. So am I reading that wrong?
so under the statute, you're entitled to litigation costs.
Yeah, well, the reason I ask is because earlier, and I probably misunderstood you, earlier you said we'd never charged for any clerical in this case. We charged for over 300,000, and instead of that, the judge gave us less than that. And I thought you said clerical was not one of the costs.
We did. So clerical is, we do tasks, whether it's my going to court.
Oh, I don't mean,
all that.
no, I don't mean you getting up and going to the copier. That's not what I'm saying.
Okay.
And maybe that's what you meant.
Oh.
Maybe that's what you meant. You meant
Yeah.
that you didn't, when you were charging for your time, you were charging for your time as an attorney, not your time as a clerk.
Correct. And I think so I may have misspoke. I think you were asking about, so Jeannie and Ellison are two paralegals, so I think you're asking about those as clerical.
Yeah.
So those as clerical, some of them we did get awarded, I assume, to the best of my recollection, but for the majority of them, we just said, we're not asking for it.
Okay.
So
But to be clear, whatever you were awarded for that would have been a cost, not an
cost,
attorney.
litigation cost.
Yeah.
And the statute clearly allows attorney fees and litigation costs. And even the judge went into all this in her third opinion. Specifically, she addressed the issues with regard to Corey Smith versus Corey. Are there any other questions that anyone would have?
I do not.
Thank you.
Thank you.
Thank you, Mr. Roney.
Thank you.
You have about 4 minutes for rebuttal.
Can you start with telling us where you get this $350 an hour issue?
By doing the calculation of the attorney's fees versus the amount by hour.
So what are the number of hours you believe that the court on the record awarded?
Do not have that number in front of me.
Well, you also, I don't think, put it in your brief either. So how are we supposed to decide that?
I'm sorry. By doing math, I apologize for that.
Well,
But
I
as
can't do
Ms.
the math if I don't know the
No,
number of
no,
hours.
I appreciate that. I really do. It's just that when you add them up and when you look at the bills, it says $350 an hour. The billing records, which were an exhibit, do say that amount of money.
Talking about a couple of the billing records from his partner.
But they're also there, when you put the numbers together, that's what it turns out to be. I've got to address a whole bunch of things that came up. First of all, clerical costs were asked for. It's in the transcript.
He just conceded that.
Okay, thanks. Now, it said that Alan brought this on behalf of the trust. It's not. The claim of interest is very simple. I am a trust beneficiary. It was not brought on behalf of the trust. He and his sister filed a probate action to remove their brother, Robert, as a trustee, which the probate court did do and found it that he had acted in most. In fact, Judge O'Brien said, in my 12 years on the bench, I have never seen a trustee act more egregiously bad than Robert Katkin. So it isn't, when we talk about different things that happen, it's not Alan who is the person here. And that's where I think that the trial court erred in its determination of the facts. So he never said it was on behalf of the trust. We talk about, he did all this litigation, he caused all these things, he made them spend all this money. There were 2 lawsuits. 2. The 2003 lawsuit was dismissed within 30 days because that lawyer filed it in the wrong court. And it was brought on behalf of Alan and Bonnie and Robert, not just Alan. Then there was a second lawsuit, 2009. That case was dismissed before it was even served on Marlene Katkin. It's the kind of rhetoric that you heard today that influenced the judge that is not supported by the facts in the record. Didn't matter how many lawyers his mother hired. And if you read the transcript and he's asked different things about lawyers, he says, I never even heard of that person.
Are those 2 lawsuits in addition to any probate actions that he would have filed in Florida?
He
Like
didn't
petition
file
to
any
a-
probate actions.
Thought he
in Florida.
petitioned to become guardian.
He with his brother and sister filed a guardianship action. And what happened is the probate court appointed an independent guardian instead. That's all. Didn't appoint nothing else. All of these allegations again, and he's got thousands of dollars from dad and wanted money from grandma. None of that came into the record. There's nothing like that in the transcript. This is just things to make Alan look bad. 2 lawsuits, a guardianship, which a guardian was appointed. So he was successful on the guardianship. And 2 lawsuits, one in 2003 and one in 2009, both relating to his father's trust to get information because they weren't giving accountings and they weren't filed. And one was dismissed because it was in the wrong court. And 6 years later, it was dismissed voluntarily before it was even served on Marlene. So you can't say that's a pattern of harassing someone through lawsuits.
Well, were any of so you've talked about 4 total. The 2003 lawsuit, 2009 lawsuit, the guardianship.
Which did not
and-
involve Marlene, it was just a
No,
guardianship
no, we're
action.
talking overall and the file of the claim of interest. So here's a question for you. If you don't remember, it's fine to let me know. This is a lot of facts, but did he have the same attorney for any of those 4?
No.
Okay.
I do know that. And the answer is no. And the claim of interest, it's interesting. Mr. Rooney said from 2002 to 2017, at no time did he ask the trustee to file suit or take any action against the deed, even though he knew about the deed. Well, if somebody is the person that the court described and Mr. Rooney described as litigious and trying to cause trouble and so forth, then why did he not take any action for 15 plus years? No action. That's even Mr. Rooney's own words. I wrote him down. At no time.
No action regarding the
deed.
subject property.
Correct. At no time did he ask trustee to file suit or.
Isn't
take
that the
any
problem
action.
though? He didn't do anything within 15 years?
Well, that's the thing. He didn't know that he had any right to it. That's why when he talked to Volchko, Mr. Volchko in 2015 says, I think you might have a right here. Let me investigate it. The statute is very clear that it's for costs relating to that action, not prior to file, not even when you file the claim.
Right, it says cost arising out of the recording of a deed.
Right.
So I don't know how there could be any attorney's fees or costs assessed prior to that date.
Right. And the same thing with the probate court action. It involved removing Robert Katkin as trustee, which happened. The court didn't claw back any property, didn't do anything, the probate court didn't take any action with respect to the deed. That probate action was to remove Robert Katkin, which it did, and made Alan Katkin the trustee. As for the information, like I said, please read the transcript about these supposed 9 lawyers and lawsuits, because it's really clear. Alan has no clue, even when various names are done, and said, my mom might have hired them. My mom wanted us to get information. As for Mr. Volchko saying he destroyed documents, I don't remember that, and I don't see a citation for that anywhere in any of the briefs. He did say, I was there and I heard this. He was asked by Judge McMillan, when you answered the first set of interrogatories or document interrogatories, why didn't you list the Florida lawsuits? And he said, because I'm licensed in Michigan and I didn't think about Florida. That's literally what he said. What you're not told is that when I came into the case, I supplemented those. And the reason that Mr. Rooney has all that information is because he got it from me during discovery. There was no attempt to hide. I turned over voluminous records to Mr. Rooney. There was no motion to compel. There was nothing of that sort whatsoever. Mr. Volchko didn't make a good decision, but that doesn't mean that Alan Katkin is guilty of malice because his attorney might have been a doofus.
When was Mr. Volchko, when was he first retained by your client?
2015, I don't
Okay,
know.
when did he start making demands?
I think in 2017, I know he sent several emails asking for information. I believe he sent 2 letters to Mr. Nemus saying that he felt the property was improperly transferred.
According to the trial court, in her opinion on the attorney fees, in 2015, Mr. Vlichko began disparaging plaintiff's title to the Rochester property and demanding the property be turned over to defendant and or the Doris Katkin truck. Wouldn't Mr. Rooney be entitled to attorney fees for having to defend that?
No, because that's not the recording of the claim of interest. You don't get attorney's fees just for answering letters back and forth. We do that all day long. People write me letters, I write letters back. There are no attorney's fees. The only way they collect attorney's fees is under the statute, and the statute says it's from the recording of the instrument.
Okay.
Things that are not in the record, that the guy didn't like Marlene. In fact, he testified he liked her a lot because she cleaned up his dad. She was his 3rd wife and she cleaned up a lot of stuff. That's what's in the record. Saying that he got hundreds of thousands of dollars from dad and grandmother, that's not in the record. that he wanted to, the issue about being incapacitated. It was a determination.
You're
by
running
a
out of
probate-
time. I've actually given you more time.
Oh, thank you.
so-
Just real quickly, it was a determination by a probate court judge that she needed a guardian. So the allegation again that he somehow was disparaging his grandmother, a guardian was appointed by a probate court judge in Florida. So,
Well, that's it, because you got 8 minutes, including our questions. So.
thank you so much. You're so very.
Thank you.
All right, have a good
Thank
day,
you, and
safe
you-
travels.
Thank
and-
you for your attention, even though I know it was a very long day.
Well, thank you for coming. I know both of you were here very early, and so were we.
Absolutely. I've been listening to you since case number 2, and it was
And you're
fascinating.
sick of us on
No,
pineapple.
no, it was fascinating. It was. There were some very interesting arguments.
And after your long day, I hope you get to go home, but I guess there's some chance you're probably going back to the office.
You're absolutely right. I've had 2 people.
Well, we get,
Oh, God.
No, I do have to go. I have a judge in Ann Arbor to whom I need to send a draft order. So I did write that I was here and I would do it.
I want to
as soon
say,
as
I want
got
to say
up.
one more thing. The case is submitted. That concludes our case call. We're done.
Thank you.
We're off the
You
record.
have a safe ride and I hope
Mr.
you all.